Hello. ಅಲ್ಲ ಅಲ್ಲಿ ಅದು ಹೇಳಿದೀವಿ ನೋಡಿ ಇಲ್ಲಿ ಕೆಳಗಡೆ. Hello.
Well, so that I can hear you, use the mic behind your ears. Speak. Well, so that I can hear you. See what is going to happen? Good. What is the matter? Who went before the AC? Who went before the AC? And it was restored. For DC, it rejected.
DC, no, my lord. DC, the proceeding for dismissal for not prosecuted. No, my lord.
Who went before the AC? Who's in the position?
You are in the position.
Who went before the AC? Posted in 2 days. Next week. DC, it rejected.
No, my lord. DC, the proceeding for
Who's in the position? Who went? Posted in 2 days. DC, it rejected.
no, my lord.
Learned advocates who are on VC, somebody is put on 2 systems.
sir. I appear for the respondent numbers.
You mute your mic. You have started 2 systems in your office. My voice is echoing back. Advocates who are on VC, somebody is put on. Where is that?
Sir. I appear for the respondent numbers.
You mute your mic. You have started 2 systems in your office. My voice is echoing back. Advocates who are on VC, somebody is put on. Next week.
I appear for the respondent numbers.
You mute your mic. You have started 2 systems in your office. My voice is echoing back. Mute ಮಾಡಿ ನಮ್ದು ಇದು mute.
That quote is muted.
Page-wise adjournments. Page number 14, number 47 to 52. Page number 14, 47 to 52. Page 53 to 60. Page number 16, syllabus 61 to 65. Page-wise adjournments. Yes, madam. Page number 14, number 47 to 52. Page number 14, 47 to 52. Page 53 to 60. Page number 16, syllabus 61 to 65. Page
61, my lord.
Already you rectify this.
ಅದು ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಪ್ಲೇ ಆಗ್ತದೆ.
ಕ್ಲೋಸ್ ಮಾಡಿದ್ರ
Close ಮಾಡಿ.
ಇವಾಗ ಬರಲ್ಲ.
ರಿಪೀಟ್ ಆಗಲ್ಲ.
Serial number 61, my lord.
page number 14, syllabus 47 to 52.
My lord, serial number 51, my lord.
Yes. Yes.
My lord, one week. Yesterday I got the NOC from previous council, my lord. Kindly 1 week time may be granted.
You are for whom?
I am for the respondent number.
All right, let petitioner come.
Serial number 61, my lord.
Page 15, syllabus 53 to 60. Page 16, syllabus 61 to 65.
Yes.
61 to 65.
61, my lord.
Yes.
May kindly
Yes.
be handled next week, my lord.
At request of counsel for the insurance company, release this matter next week.
Please.
Inform other side.
Yes.
Page number 17, syllabus 66 to 69. Page number 18, syllabus 70 to 76.
Request of counsel for petitioner released next week.
Page number 19, syllabus 77 to 79.
R5 has died. Further counsel for the petitioner submits that respondent number 5 has died. If a week, 2 weeks time is granted, he would bring the file necessary application to bring the legal representatives on record. Accordingly, 2 weeks time granted. Interim order, if any, extended till next date of hearing.
In seal number 78, I appear for the petitioner, my lord. I have served the amended petition by way of email. I undertake to serve it by physically also, my lord.
No, they have received it. They want
Please.
time to file objections.
Please, my lord. I'm grateful.
A week's time? Any urgency? At the request of learned AGA, release this matter after 3 weeks to facilitate the government to file statement of objections.
Lord, there is an interim order which operates till today, my lord.
Interim order, if any, stands extended till next date of hearing.
I'm grateful, my lord.
Right? Why 1 week? For whom are you? Claimant. You don't want to argue. Who are you, sir? It's an MFA, you have to be appellant. So why can't you go on with the matter? Already 10 years, you want to take it for the next decade. Don't be so callous in these MVC cases. Request of non-counsel for the appellant. A week's time is granted as last chance. Follow.
Members, number 1.
Yes. So you want from Anegal to Gauri Bidinur. Have you filed anything in Gauri Bidinur? Heard learned counsel for the petitioner. Issue notice to respondent. Counsel for petitioner to take out this petition to counsel representing the respondent before the court at Anekal or at Gauri Bidinur. For the proceedings in MC number 5059, pending on the file of third additional district and sessions judge. Is it before district and sessions judge? Sessions judge Anekal till next date of hearing. Today? Yes. All right. At request of learned counsel for KVT respondent number 4, release this matter on Monday. All right, pass over. Counsel for the petitioner filed a memo. So withdrawal of this petition. They are joined together or separated? Filed a memo seeking dismissal of this petition has not been pressed. Placing the memo on record. This petition is dismissed, has not been pressed. Respondent is- Annapurna Chandrasekhar. Last date correct ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ? Also,
Serial number 6.
I appear for the respondent number 6 here. If I for time here, 1 week.
what is this reminder 1, 2, 3?
Alert.
No, Bandila, what is there?
Healthier not received.
Again, from where it has to come?
The government, with the records,
No, from where it has to come from?
the DC and ACR.
Where, which district? ಅಲ್ಲಿಂದ ಬರಕ್ಕೆ ಇಷ್ಟು ರಿಮೈಂಡರ್ ಬೇಕು. Right?
2 weeks, 2 days company.
Learned HCGP submits that he would support within a week's time. Release this matter next week. Learned counsel submits that he would comply within a couple of days. Hence, release this matter next week. Huh? No, what about this R3?
I'll start copy on the R3.
I'm sorry? Next week. Why? Release this matter next week at request of counsel for petitioner. Proposed loss of the petition. R8. Who appears for R8?
Even, yeah.
You are grantee? Purchaser. Who's R8? Who are the others? Who's appearing for R5? So R4, 6 to 9 are who? No, Jeevan doesn't appear for R5. Hmm.
Even के R4, R6, 8 and 9.
How the council can furnish? No, the council will not be in touch with anymore. Okay. Which provision?
22.
Just to furnish details. Hmm.
Contract between the leader and the deceased party shall lead to success. Overall.
Yes.
Due diligence has been taken. If there are no letters, then the absence of also.
No, this court can direct him. Suppose he says, I have no information. Learned counsel for the petitioner files a memo submitting that the respondent number 8 reported the death of R8, this respondent number 8 on 12/10/2021. Despite best efforts made by the petitioner, he is unable to find out the details with regard to the legal representatives of deceased respondent number 8. In view of the same, counsel who represented the respondent number 8 is directed to furnish the details of legal representatives of deceased respondent number 8 within a period of 2 weeks from today, relist after 2 weeks. Say Khadri. You have to unmute.
1 week time to complete office objection.
Week's
Tomorrow
time
itself, everything is ready.
to rectify the objections. Two weeks time granted. Needful done. Issue notice to R3 and 4. Next. Two weeks time granted. Needful done. Issue notice to unserved respondents. R3 rejected. Notice to R3 is returned with Shara as partly rejected. Hence, the same is held to be sufficient registry to show the name of R3 in the cost list. 2 weeks. If needful done, issue notice.
Much obliged. Much obliged.
Each time granted at request of petitioner. If needful done, issue notice to R1. Two weeks time to rectify the objections raised by registry. I said postal covers are they're not carried out. Learned counsel for the petitioner is permitted to carry out the amendment forthwith. Carry out now.
I appear for petitioner in this matter, my lord. I need to write a letter to the petitioner's LRs and I will get an information, my lord.
Sole petitioner.
Yes, my lord.
When did he die?
He died when I last mentioned about a month back to that date, my lord. Exact date is also not known to me. Some relatives picked up the phone on that day, informed that he has expired. And I told them somebody has to approach me to take the notice to the respondents. And I will write a letter, my lord. 4 weeks or 6 weeks time may be granted. So that there will be a record of having intimated them regarding the matter.
While order dated 16/8/2022, this court passed a peremptory order on the submissions of learned counsel for petitioner with regard to the death of petitioner. And if legal representatives are not brought on record by the next date of hearing, the petition would stand abated. Till date, the legal representatives of petitioner are not brought on record. Hence, petition abates. Yes.
Number 18.
Petition abates, sir.
Yes, my lord.
What is the application? Huh? What amendment? What? ಎಲ್ಲಾನು ಕೇಳ್ಬೇಕೇನ್ರಿ?
My lords, I am for R5 and R7, my lords. I am the
Yes.
amicus appointed.
Even the R7. Why amicus, madam? What happened to the R5 and 7? What is this matter? GMCPC, you are for? What is the prayer? What is the amendment you are seeking? What is unnecessary? You're for R6. What's your objection? You're not a party to the joint memo. No, they have filed some joint memo, settle the matter, dismiss the suit. You are not a party in the joint memo. All right. But we'll allow the amendment and then hear you.
My lords, I have not been I'm not being served with a copy of the IA, my lords. I may be served, the matter may be taken up next week, my lords.
I don't serve copy on the other side. ಕೊಡ್ಬೇಕಲ್ಲ ಎಲ್ಲಾರು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ. Learned counsel for the petitioner to serve copies of application IA number 1 of 2022 to the learned counsels representing the respondents. Release this matter next week. Next week, madam.
See first, much obliged, my lords.
Rajkumar R for R6 ಅಂತ ಇದೆ. GV Shashikumar. File wakalat. Why you don't want R Rajkumar? All right. Registry to show the name of GV Shashikumar as counsel for R6 instead of learned counsel Rajkumar R in the cause list.
Much obliged.
Yes. Tondilla. A week's time granted. Take steps with respect of unserved respondents. Two weeks. If needful, done, issue notice to respondents.
Yeah.
Week's time granted if needful done, registry to issue notice to the unserved respondents. Now, what is this withdrawal and dismissal of property? What does this matter? The orders are challenging here. You are aware of any facts? What is that order? Whether there is any interim order here? What is the proceedings now that is pending in the FDP? Original suit only is pending. So that commissioner order which is passed, that is put in stay. So that is stayed. Now why you are unable to take out notice? No, already there is a peremptory order for dismissal, stands dismissed. Already there is an order. You have to recall this order. Already there is an order. 2 weeks. You ought to have filed it in 2 weeks in 2021 February. Now we are in 2023, almost February. 2 years you have taken. Dismiss it. Berkol, wide. You are appearing for 3 and 4. So this was ordered for whom? Yes. Unserved respondent is 1 and 2. All right. What is the relief against 1 and 2 in the suit? Now what remains here? You don't bother. You don't read the papers. Berkol, in view of order dated 9/2/2022, wherein this court passed a peremptory order for taking out steps bar notice to the unserved respondents on the counsel representing the respondent before the trial court, which has not been taken within the stipulated period of 2 weeks from 9/2/2022. 9/2/2021, this court had passed an order of dismissal on its own if the steps are not taken. Learned counsel for the petitioner submits that he has not taken out the steps as ordered by this court. Therefore, left with no alternative, the petition as against R1 and 2 is dismissed, stands dismissed in compliance to order dated 9/2/2021.
23. We are
2 weeks time, steps to be taken in respect of R3 and 6. Fresh steps.
May appear for petitioner in this week's time.
A week's time granted to rectify the objections raised by registry.
Obliged.
What is the objections? For what? What is the objection? Is it service of notice copy of that or what? Week's time granted to rectify the objections. Two weeks. Next. What is this? When did R3 die? Huh? You're not filed. What is this maintainability? What are you challenging? A week's time is granted to comply and if needful done issue notice to the unserved respondents and steps in respect of R3.
My lord, I appear for respondent, letter 3, 4, 7, and 8.
Huh? Served, R1 was not claimed. You have to take fresh steps again. Niviyarge, Prakash. Who are you appearing for, Mr. Counsel?
My lord, I appear for respondent 3, 4, 7, and 8, my lord.
You have to take fresh steps. A week's time granted to take fresh steps in respect of R1 and 2.
58.
Obliged.
Learned counsel for the petitioner is permitted to serve copy of of the petition to the learned counsel representing the respondents R5, 7, 8, 9, and 11. What about 8 and 8? R5, 7, 8, 9, and 11. Next.
Lord, I appear.
Next state appearance.
Lord, I appear for the petitioner, my lord. It may be taken up next week, my lord. I am not in town. My lordship may have it next week, my lord. I will make my submission with regard to the affidavit filed by them, my lord.
You are appearing for whom? Who are you? Grantee? You are purchaser. You are appearing for grantee. What is this
Grantee, my
affidavit?
lord.
What is this affidavit?
They filed the affidavit,
What
my
this
lord.
affidavit was sought to be?
My lord, I will make my submission. Your lordship may have it next week, my lord.
Request of learned counsel for petitioner released next week.
Yes, much obliged.
You have filed. Learned counsel submits that she has filed necessary application with regard to deceased R4. Bring the legal representatives, registry to verify and put up relist week after next.
31.
2 weeks time to rectify the objections. Interim order, if any, extended till next week. 2 weeks time, if needful done, issue notice to unserved respondents. And steps. Huh? 16, 11, 19. The postal shara dated 16, 11, 19 is returned with regard to R1 and 5 as dead. Steps are not taken to bring legal representatives of the deceased R1 and R5. Hence, petition as against 1 and 5 abates. Of R1 and 5. You are appearing for whom? R1 and 5 LRs are already on record in the form of what? What called learned counsel for the. You have already filed this or you are filing this today? has filed a memo today submitting that the respondent number 1, who died on 22/5/2014, is represented through her legal representatives in the respondents 2, 3, 6, 7, and 8, and they are already on record. With regard to respondent number 5, who died on 11/1/2018, her legal representatives are on record as respondent number 3 and 4. So 3, who is 3 is the representative, common representative of both. Hence the submission and the memo of learned counsel for the petitioner is placed on record. The legal representatives of R1 and R5, as stated in the memo, to be incorporated as LRs in the petition, and amended petition to be filed by serving a copy of the same to the other side. No, now you have to. No, now LRs have to come on record now. Oh, R6 and 8 are the LRs now of R1. Sir, the LRs of these people were not brought on record before the trial court. Take out notice to the counsel. The counsel for the petitioner to take out notice on the counsel representing respondents R6 and 8 to 10. The earlier order appeared to cancel. Yes. This is a paper publication. Where is the paper publication? Yeah. The counsel for the petitioner has submitted the publication of newspaper wherein the notice to respondent number 1D was taken out in the Kannada Prabha daily newspaper of Kolar edition dated 23/12/2022. Call out the name.
Sujata.
The respondent number 1D is called out in the open court. There is no representation either by herself or through her counsel. Hence, the notice to R1D is held to be sufficient registry to show her name in the cost list. Order, if any, extended till next week. When? Huh? Aitala, 5/2/21. It abates. The postal shara dated 5/2/2021 is regard to R6 is returned as died. Till date steps are not taken to bring legal representatives. Hence, maybe it abates by law. The petition as against R6 abates. Who's wanting to retire? Huh? Return the file. Why? No, the rectification. Return the rectification file with NOC to 61st petitioner. He has accepted the same on behalf of all other petitioners. Sumana Baliga. You are appearing on behalf of Sumana Baliga. Where is she? What happens? The course is not recognized. So the results is announced. That is by the you are appearing for the college, Raghavendra College, 61st petitioner. What about others? What about others? You may be permitted to retire, but there's no acknowledgement. Called. Then counsel for the petitioner has filed a memo seeking retirement on the ground that no objection wakalat has been taken by the 61st petitioner on behalf of all other petitioners as well. But nothing is forthcoming along with the retirement memo to show petitioner number 61 has accepted the NOC or permitted the retirement of the counsel on record. So also nothing is forthcoming with regard to petitioners number 1 to 60. Hence the retirement memo cannot be accepted. Your retirement memo cannot be accepted. 2 weeks time to comply. Serial number? Serial number. Why you need 4 weeks time? Why you need 4 weeks time to bring the LRs? What is the interim order? All right, for the serial number 14 early. 3 weeks time. Interim order extended till then. No representation on behalf of petitioner released after 2 weeks. is this? When he has died? ಹಾಕಿದಾರಲ್ಲ LR application. I9 is for to bring whom? Loss of proposed R24. R9 ಗೆ ಮಾಡಿ R12 ಗೆ ಮಾಡಿಲ್ಲ. So date of death is prior to 21. 13/12. The order sheet dated 13/12/21 reads that respondent number 12 has died. Till date, no steps are taken to bring the legal representatives of R12 with petition as against R12 abates. To consider the other pending applications list next week. Third, you brought the LRs on record. He died on 16 in the year 2016. Barcode. Learned counsel appearing for respondent number 5 has filed a memo reporting the death of respondent number 4 on wide memo dated 12/10/2022, death having taken place on 22/3/2016. Till date, the legal representatives of R4 are not brought on record. Hence, petition as against R4 abates. What is this IA1 for additional grounds? You have filed this? All right. IA1 of 21 would be considered along with the main death petition. Notice has to go. There, you appear for R5. We'll allow the application. R5 to 9, huh? It's on time. Application on time. This application is filed by the petitioner to bring under Order 22, Rule 3 of the Code of Civil Procedure, read with Article 227 of the Constitution of India. Bring the legal representatives of deceased R5 on record in the form of R5A to D. I have perused the affidavit annexed to the application. Reasons assigned appear to be bona fide. You have to give proper reasons in your affidavit, not a formal affidavit. This is not criminal procedure. And neither have you stated in your application. Somewhere you have to say, narrate. The application is on time. The counsel for respondents number 5 to 9 has already filed wakalat on behalf of R5 to 9. I do not find any legal impediment to allow the application accordingly. IA number 1 of 2022 is allowed. The legal representatives of R5 are permitted to be brought on record as R5A to D. Counsel for the petitioner to carry out the amendment and serve copy of the amended petition to the learned counsel appearing for the respondents.
41.
All right, release this matter. Week after next. Week after next.
Lords, appear for the petition and serial number 42.
41.
Sorry, my lords.
On furnishing. Week's time is granted. If needful done, issue notice to the unserved respondents. Yes.
Lords, serial number 42 appear for the petitioner. Lords, by virtue of the judgment of this honorable court in WP 6013, the prayers on this matter may not survive for consideration anymore, my lords. However, if I may make a submission, if liberty may kindly be reserved for in the event that the state challenges the order of this honorable High Court and is successful for the honorable Apex Court, I may be permitted to restore this petition, my lord, or re-agitate the matter.
What is this summons substance? What is the prayer sought?
My lord, this petition was filed challenging actions of the respondent school in violating the provisions of the Karnataka Education Act and the rules framed thereunder. The specific provisions of the Act and rules which were in question have been held to be ultra vires by this honorable court in WP number 6013.
Comply with section 48 of Education Act.
Yes, my lord.
Yes, Mr. Counsel.
That is not settled by this author. Griefs which she has claimed against my institution, I'm a minority, private and unaided minority. Section 48 is against how this petition does not survive.
That is what she says. So we'll permit her to withdraw the petition. You want to withdraw the petition?
I'll withdraw the petition because I may be liberty kindly be reserved to re-agitate in the event that the state is successful in its challenge against the order passed by the Honorable High Court in 6013, my lords. In that event, my lords, the liberty can be reserved.
In that liberty to revise one challenge, except one of remedy lies before the appellate.
The status challenge is what she says. Status challenging the order passed by the court, this court. So in case the state succeeds, then she should be given the liberty.
But at the moment, I don't think there is any challenge so far.
So that is in situation where if the state challenge and if the state succeeds, only then this situation of liberty will arise. So let the liberty be given to her, and if at all the state challenges, again, that's a question of if and but situation. You are representing which respondent, Mr.
4 to 18.
Yes. Your counsel practicing here, Mr. You are a designated senior counsel. All right. You're coming from Bombay. Yes, madam. We will dismiss this petition as having become infructuous. Or you want?
It may be dismissed with liberty may kindly be raised, or I'll withdraw seeking liberty, my lords.
All right. That's good. Learned counsel for the petitioner is present before the court. Learned counsel for the respondent, number 4 to 18, is present before the court along with learned AGA, appearing for R1 and R2. Full stop. Learned counsel for the petitioner submits that the prayer in the writ petition would not survive anymore for consideration for the reason
relating to section 48 is in related to January.
So now that is struck down. Section 48 has been struck down.
The relevant part of the order, section 48 along with the other sections are contrary to Article 44 Constitution. That are said to be unconstitutional private unaided execution.
So this order is passed. This order is passed by which court?
Single bench of this honorable court.
And as far as Rule 4, which obviously applies to this, it's ought to be applied only for etc. But that Rule 4 is also not, that issue is also settled by the order dated 1/12/22, which says Rule 4 of Karnataka education institutions are allowed.
This is a recent judgment which was passed by His Lordship Justice.
Please, my lord. Please, my lord. Same judgment.
The private institutions would have the liberty to fix and state will not have. Is the same thing?
Please, my lord. Same judgment.
All right, and the in Bardhan. In view of the coordinate bench of this court having struck down rule section 48 of the Education Act and also the rule 4.
Rule 4 of Karnataka institution, regulation of certain donation rules 99.
Being declared as ultra virus to the Education Act. Yes. By the single judge, by the division bench. So you have filed review. We filed preferred review or not preferred? All right. Now that you agitate, let them wake up and then agitate. All right. In view of the same, the prayer sought in the writ petition would not survive. Accordingly, this writ petition is dismissed as withdrawn, reserving liberty to the petitioners to agitate if the state challenges the same and succeeds in the said appeal, if any preferred by the state.
Much obliged, my lord.
Yes.
By law.
No, of course, that is subject to legal right is inherent as applicable by law.
Much obliged, my lord.
Yes. So what is the non-compliance now? Comply that first.
Now, you have to kindly commit the persons may not complete 8 years of service. 8 years of the course may not be 8 years. They had extended the period. I have produced may not to. Nine by 24, page 2, you know, 3 by 23. Here, we not.
That is 13. This is BTU.
Now, we not page 3 mechanisms in Petition, item number 4, eligibility for wage benefit. Must have completed course in full, that is 8 to 10 semesters as of for all.
Yes, who appears for the respondent? Your VTU. So you have permitted them.
Actually did not complete the course.
Page number 3 of your notification. Of notification. Now, where are you reading? PG. Must have completed the course. You have completed. Have you completed the course? All right, yes, completed now. Correct. That what is the condition precedent? That you should have completed the course. That is full 8th and 10th semester. This is prospective or retrospective? All right. You have not completed the course when you came before this court. Where is it showing that this is not applicable to the petitioner or retrospective or prospective? This is applicable to which batch of students and from when? It's a one-time measure. Give the benefit. He has taken by virtue of an interim order. It's a one-time benefit. He should be entitled and should inure to his benefit. Correct. That's right. But you're giving, university is giving a one-time measure to facilitate these students. Why you want to deprive him? Correct. But you can consider him also. It's a one-time measure. Since an interim order was granted, if the court had not granted, then now how you are going to overcome the court order? No act of the court can prejudice the petitioner. That is the interim order. That will be again subject to outcome of writ petition. No, that is backlog again. No, the third semester and data communication. No. The course in 2 backlog subject, that is mathematics in 3rd semester, data communication in 5th semester. No. Please understand. Whether he have completed the course. When? Before filing the writ. Completed the
I think dispose of the amount in petition to become more complete. How many good factors? When the petition was filed, the petition did not. Any models was good.
Totally, how many semesters? He's completed 8. No. But on the time when he came before this court, he had completed 8 semesters. He had not taken 7, but he completed the course. Eighth semester he had already completed. He had not taken 7th and the 2 backlog subjects. Maybe here the question is whether he had completed the course. Course is completed by finishing, but he may not have taken the semester, one of the semester.
But he did not complete the course in 8 semester. He has completed the course.
But that no, your notification does not say so. The notification says he should have completed the course.
Completed the course in 8 and 10 semester and here for all the semester examination. Then only this notification will be. Other than the date where the petitioner wrote this. Yeah.
But he had taken the 8th semester. Not now. What he says is, before the 7th semester, he had completed 8th semester, but he had. Where do you say that you have completed the course?
Para number 8 of the petition. Page number 6. Para number 8. They have given any selected page number 6, not irrespective. Then notification from 1980. Also, kindly see the IAM. I have in detail not everything.
Sir, is it your contention that you had completed 8th before the 7th? You had completed the course. That means you had taken the 8th semester.
But they not completed.
Where? You read para number 12, para 13. Sir, you read para 13, page 9 of your writ petition. Read the next para below the maximum. So that means you have not taken the 8th semester.
The person to the entry model, granted based on the code earlier appeared for all the subjects in so yeah, but in this the result of The one-time benefit.
All right. Yes. We'll permit him. What remains in the writ petition? We'll dispose of the writ petition because he has taken the examination pursuant to the interim order, and this is a one-time measure that will. Good. Third learned counsel for the petitioner. Learned counsel representing the respondent. Number 1 and 2. Who's this Mahesha for R3? All right. Petitioner is an engineering student in the third respondent institution, college. The petitioner got admitted for the academic year 2012-2013 for a 4-year course. For which combination is this? Information in the subjects of information and science. Information science and engineering. The petitioner had attempted the semester examination and he had cleared the examination. But while he attempted to appear for the 5th semester, he was informed by the college authorities and the university that he is ineligible in view of 4 remaining backlog subjects, as against 2 subjects permissible by the university regulation. Petitioner had appeared for the backlog examination and he could not clear the subjects. However, in 2016 and 17, among 4 subjects, supra, the petitioner cleared all subjects except mathematics 3 of 3rd semester and mathematics 4 of 4th semester. Consequently, he became eligible for appearance in the 5th semester. Thereafter, the petitioner could not pass 1 subject in 5th semester and 3 subjects in 6th semester. Hence, the 4 subjects along with remaining previous backlog subjects remained as backlog subjects for the petitioner. So also, in the year 2018-19, petitioner could not become eligible for the 7th semester in view of the backlog subjects. In the year 2019-20, petitioner was permitted to appear for the backlog subjects, and accordingly he cleared subject of the 6th semester and 1 subject of 4th semester, due to which he became eligible for 7th semester in the year 2020 and 2021. The petitioner ought to have completed his 8 years of studies as against 5 years of the course. 4 years of study as a 5 years of course. 4 years of the course. You have written 5 years in your petition. However, the petitioner had to clear the remaining backlog subjects of mathematics 3 in the 3rd semester and data communication in the 5th semester. He was not permitted to take up the 7th semester as he had completed 8 years of study and he was not eligible to appear for the 7th semester for further examination. Hence, the petitioner filed the present writ petition. So, a prayer before this court to issue a writ of mandamus directing respondents to permit him to appear for the 7th semester examination, along with 2 backlog subjects, namely Mathematics 3, Roman 3, in brackets 3rd semester, and data communication within brackets 5th semester. And specifically to extend the period of completion of course by 2 years in terms of notification dated 7/11/2020. Full stop. By virtue of an interim order dated 4/12/2020, the respondents were directed to permit the petitioner to write the examination of 7th semester of the course in 2 backlog subjects as stated supra of mathematics and data communication, subject to the outcome of this writ petition. This being the state of affairs, the university issued a fresh notification or guidelines dated 9th December 2022, which is placed on record by the Learned Counsel for the petitioner via memo dated 2/1/2023, which is not disputed by the Learned Counsel appearing for the respondent, wherein the notification issued by the university appears to be a one-time measure to facilitate the students for extra attempts registered under the umbrella of the VTU from the year 1998-99 for the batches covered under the benefit of BE, BTech regular and other lateral entries and courses as mentioned in para 2 of the notification dated 9/12/2022. The petitioner comes within the first batch, that is BE, BTech regular of the year 2012. So you have provided 2 additional attempts also. Para number 3 reads as under number of additional attempts, 2 additional attempts, extract para number. So thereby he gets 2 additional attempts. The one-time measure adopted by the university via the notification dated 9/12/2022 provides extra attempts to the students having registered under the umbrella of VTU from the year 1998-1999 and petitioner having enrolled in the year 2012-13 would come within the ambit of this notification. However, Learned Counsel appearing for the university contends that as per para 4 of the eligibility to avail the benefit, the UG student must have completed the course in full, that is 8/10th semester as applicable, and appeared for all semesters examination at least once, and having backlog subjects to complete the degree in full. On the basis of this paragraph number 4, Learned Counsel for the respondent university contends the petitioner would not be entitled to the benefit extended by the respondent university. The fact remains that by virtue of an interim order dated 4/12/2020, petitioner was permitted to take up the 7th semester and also the backlog of 3rd semester and 5th semester. And it is submitted across the bar that petitioner has completed the course, having taken the 8th semester and cleared. Results are announced. Results are withheld. So you have to announce the results. So you have withheld it. Therefore, the petitioner has taken the 7th semester course along with 2 backlog subjects and also the 8th semester examination. In view of the same, petitioner would be entitled to the benefit of this one-time measure introduced by the respondent university and would get the benefit of extra attempts by virtue of this notification, which covers the batches of 2012 as per the notification. Is the contention of learned counsel for the petitioner that now pursuant to the interim order and having taken up the 7th semester and 3rd and 5th semester examination, he has passed in all the subjects in the month of September 2021. However, the marks card of the subjects have been withheld by the respondent university in view of the directions interim order passed by this court. Contends that the results have been announced in the official websites of the college, but has not been declared because of the orders passed by this court. Full stop. The notification dated 9/12/2022 inures to the benefit of petitioner would come within the ambit of one-time scheme, one-time measure, and an extra attempt provided to all the students after the year 1998-99. And therefore, the respondents would be bound to declare the results of the petitioner for the subjects of 7th semester and 3rd and 5th semester. Allah? 3rd and 5th. 3rd and 5th. And declare the results of the petitioner. Full stop. Accordingly, I pass the following order. A writ of mandamus is issued to the respondent number 3, college. You have to announce the result. College has to announce the result. Respondent number 3 is the college. R3. No, which respondent is the college? R3. R3 is directed. The mandamus issued. R3 is directed to declare the results of the petitioner with regard to semester 3, semester 5, and 7th semester examination, and any other backlogs. You have any other backlogs of the 7th semester? As the petitioner would be entitled to the one-time measure granted by the respondent to university by way of notification dated 9/12/2022. Full stop. A writ of mandamus is also issued to the respondent number 3, 213, no? No, after the announcement of result by the college, the university will have to issue the decree certificate. Correct. The college shall, this is the respondent number 2 university is directed to issue the decree certificate. The provisional as well as final degree certificate, if the petitioner is otherwise entitled to and has cleared all subjects. That's all. You have taken 6th and? And also declare the results of 6th and 8th semester, which is also taken pursuant to the interim order. Madam, just add. One more para that pursuant to the interim order, the respondent college and university had permitted the petitioner to take up. College had permitted the petitioner to take up the 8th semester examination, and it is stated that he has also cleared the 8th semester examination. That's why, so consequently 8th semester also will have to be declared. So in the operative portion, that is why you will be issuing the degree if he is eligible. If he is otherwise eligible and entitled to, only then the degree certificate will come. Otherwise, if he has flunked, then it will not get. Then the the respondent number 3 shall also announce the results of 8th semester examination. The respondent number 2 shall issue the degree certificate if the petitioner is otherwise entitled to and eligible in accordance to the regulations and the rules of the university. Accordingly, petition is disposed of. All right, possible. Right. All right. Learned counsel for the respondent submits he has filed a rejoinder. Objection, statement of objections to the petition. Registry to verify and put up the same. Relist this matter after 2 weeks. Interim order, if any, is extended till next date of the. Identification or allotment? Listing of the petitioner. Madidara? Yes.
numbers are not.
Why did you get them here? No, you could take instructions and send them by. Yes, you can make here. Yes, you are entitled. Yes. Your prayer is to include the petitioner in the examination as an examination center. That's your prayer.
That's this first page.
Hmm.
7/2023, can inform me concerned DPIs that is not signed the.
Hmm.
But page 3 minutes, this is the latest which governs of the center.
Hmm.
But here minutes, maybe serial number 6.
Hmm.
ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ ಕನಿಷ್ಠ 5 ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ತಾಂತ್ರಿಕ ಪರೀಕ್ಷಾ ಕನಿಷ್ಠ 5 ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ನಿಗದಿಪಡಿಸಿ. There should be minimum of 100 students for practical examination, 500 students for theory examination.
Hmm.
So, members in the petitioner's institution, there are 85 students. Second page.
What about theory? Hmm.
Next page.
Hmm.
Once it becomes the mass copy numbers, afterwards they are not nowadays I college just to the college extra and the other not they're all not
Hmm.
Next condition. Exactly. Second. Nobody comes to
next page, checklist where we follow 5 hours.
Hmm.
This is my committee.
Hmm.
And it is checklist.
Which? Hmm. 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 Yes. Hmm.
ಶೈಕ್ಷಣಿಕ ಸಾಧನಗಳು ಹಿರಿಯ PUC ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷೆ ನಡೆಯುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದ ಮುಖ್ಯ ಶಿಕ್ಷಕರ ಪಡೆದ ಶೈಕ್ಷಣಿಕ ಸಾಧನ ಸ್ವಾತಂತ್ರ್ಯ ಪರೀಕ್ಷಾ ನೀಡಿದ ದೂರಿನ FIR ದಾಖಲಾಗಿದೆ. ದ್ವಿತೀಯ PUC ವಾರ್ಷಿಕ ಪರೀಕ್ಷೆಗಳ ಆರಂಭವನ್ನು ಕಾಲೇಜಿನ ಪ್ರಚಾಲಿತರಾಗಿ ಅಥವಾ ಆಡಳಿತ ಮಂಡಳಿಯವರಾಗಿ ಈ ಬಗ್ಗೆ ಇಲಾಖೆಯಲ್ಲಿ ಬಂಧನ
Yes.
Where each student will the theory examination conducted from 9th of March was obviously right here. College is 6.5 kilometers. They should be changed.
Is there a public mode of transport for the students to go?
Public mode of transport.
No, but otherwise, whether the formal college is located where, how?
Because we also have done there.
Yes.
See, timetable for examination.
Where is it stated? It's chapter? Hmm.
One copy of the college, there are 80 college and 80.
Yes. The Venkataramana Swami PU College. Huh? Hmm. 149 students.
There is standard for all other.
Yes.
Can I have a look at the secular page number 3? How we produce that chart? There are two categories of examination centers as a gather and the secular. One are those which are already nominated as the examination center in 2022. And the ones which are required to be nominated as such for 2022. These are two categories created in the center. So far as the first category is concerned, you cannot exclude. Until and unless there is a strong reason for its exclusion, which is a decision to be taken even before you have seen the examination centers for the concerned category. This is how the secular is. So far as the new examinations of 2023 is concerned, the checklist procedure is applied. Checklist what the level is referring to. It's a procedure contemplated for the examination centers to be allocated for the first time for 2023. There is no dispute about the fact that this was an examination for the year 2020. From there, I guess it happens. Benchmark or Managanda for the purpose of fixation of the examination centers is the one which was followed for the year 2022. The examination centers which are already there in 2022 should form the basis for fixation of the examination centers. What I understand. It may be have looked at clause 1. Jilla implementation to ನೇತೃತ್ವದಲ್ಲಿ 3 ಸದಸ್ಯರು ಇಂಟ್ರೆಸ್ಟ್ ಸಮಿತಿ ಜಿಲ್ಲೆಯ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿಕ ಹಾಗೂ ಅಧಿಕಾರಿಗಳಿಗೆ class 3 is very important. ಹೊಸ ಪರೀಕ್ಷಾ ಕೇಂದ್ರ ಮಂಜೂರು ಮಾಡುವುದು ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ 312/2010 ಪ್ರಕಾರ ಹೊಸದಾಗಿ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳನ್ನು ಮಾಹಿತಿಗಳನ್ನು ಆಧರಿಸಿ ಜಿಲ್ಲೆಯ ಎಲ್ಲಾ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ 3 ಸದಸ್ಯರ ಸಮಿತಿ ಖಾಲಿ ಭೇಟಿ ಸರ್ಕಾರಿ ಕಾಲೇಜುಗಳಲ್ಲಿ ಲಭ್ಯವಿರುವ ಗುರುತು ನೀಡುವ ಅನುಮತಿಗಳನ್ನು ಕೂಡ Clause 1, 2, 3, 4 pertains to those which will be nominated as the examination centers for the first time for the academic year 2020. Now, what about the examination centers for the academic year 2020? Already nominated. Can I have a look at clause 5? 22 ಪರೀಕ್ಷೆಗೆ ನಿಗದಿಪಡಿಸಲಾಗಿದ್ದ ಪರೀಕ್ಷಾ ಕೇಂದ್ರವನ್ನು ರದ್ದುಪಡಿಸಿದಲ್ಲಿ ಸೂಕ್ತ ಹಾಗೂ ವಿವರವಾದ ಕಾರಣಗಳೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸುವುದು. ಅವಶ್ಯವಿದ್ದಲ್ಲಿ ಮಾತ್ರ 22 ಪರೀಕ್ಷೆಗೆ ತಮ್ಮ ಜಿಲ್ಲೆಯ ಹೊಸ ಪರೀಕ್ಷಾ ಕೇಂದ್ರ ಸಲ್ಲಿಸುವುದು. There is a prohibition to include the new centers if there are old centers. If there are old centers, avoid centers as much as for this purposes. When this exercise has to be undertaken, this is an exercise to be undertaken prior to the date of this examination.
So 2022, you are existing center? That's not in dispute.
Now, ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷಾ ಕೇಂದ್ರ, what my 11th and red dots in class 6 is not the full of it. ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ ಕನಿಷ್ಠ 3 ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ತಾಂತ್ರಿಕ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ ವಿದ್ಯಾರ್ಥಿಗಳಿರುವಂತೆ ನಿಗದಿಪಡಿಸುವುದು. Not that the concerned college should have 100 students. These 100 students be nominated to a concerned examination center so for a concerned practical exam. 500 students so far it pertains to the theory examinations. Not that I should have 100 students. Under the circular.
Read that again.
ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ ಕನಿಷ್ಠ 100 ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ತಾಂತ್ರಿಕ ಪರೀಕ್ಷೆ ಕೇಂದ್ರಗಳಿಗೆ ಕನಿಷ್ಠ 500 ವಿದ್ಯಾರ್ಥಿಗಳು ಇರುವಂತೆ ನಿಗದಿಪಡಿಸುವುದು.
So 100 should go there.
100 should go there.
Okay.
Then ವಿದ್ಯಾರ್ಥಿಗಳ ಸಂಖ್ಯೆ ಕನಿಷ್ಠ ಸಂಖ್ಯೆಗಿಂತ ಕಡಿಮೆ ಇದ್ದು ಪರೀಕ್ಷಾ ಕೇಂದ್ರವನ್ನು ನಿಗದಿಪಡಿಸಿದಲ್ಲಿ ಸೂಕ್ತ ಕಾರಣಗಳೊಂದಿಗೆ it's not a it's evidence of the students. In case there is some examination center required to be accessed, but it is closer proximity to some of those students. But another college will get a very high distance. There may be only about 60 students there. In such circumstances, you cannot say either daily or large scale, broad-based administrative ideas. Think about the contingencies that they provide for. And then, ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷೆಗಳಿರುವ ವಿಷಯಗಳ ಸಂಬಂಧಿಸಿದ ಸಮಾಂತರ ವಿಷಯಗಳ ಪ್ರಯೋಗಾಲಯಗಳನ್ನು ಭೇಟಿ ನೀಡಿ ಪರಿಶೀಲಿಸಿ ಪ್ರಾಯೋಗಿಕ ಪರೀಕ್ಷೆ ದ್ವಿತೀಯ PUC ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳ ಪರೀಕ್ಷೆ ನಿಗದಿ ಹಾಗೂ ವಿದ್ಯಾರ್ಥಿಗಳ ರ್ಯಾಂಡಮೈಸೇಷನ್ ಮಾಡಿಕೊಂಡು ಯಾವುದೇ ಕಾಲೇಜಿನ ವಿದ್ಯಾರ್ಥಿಗಳು ಅದೇ ಕಾಲೇಜಿನ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದಲ್ಲಿ ಪರೀಕ್ಷೆಗೆ the rules at page number 8 on the recreation papers. Examine the rules. They can't seek to overlook the rules by means of these executive instructions.
Yes.
At page 42, rule 8.
Yes.
Examination center examination should be conducted at such centers as to be specified by the department. Such centers should be located in any institution or other premises as the department giving or cooperation of this department. All regular students and instruction generally with examination. This is the rule. Rule 8 says that as far as may be possible, since you have studied in that college, committed to take examinations in forest, provided that is notified as an examination center for the concerned academic year. Not otherwise. If it is not an examination center, then it need not be. But if it is nominated as an examination center, they should be the examination there. Reason is proximity. That gives principle once again, it speaks about the manner in which the student can have access to the examinations. That is how rule 8 reads. This is like actual benchmark for fixation of the examination center. The examination center should be fixed in a manner that page 42 that located in any institution or other premises that this having due regard to convenience of location. Convenience of location.
So does is 8.1 not contradicting 8.2?
8.1 H2 facilitates how H1 should come into existence. H1 says fixation of the examination centers should be having the broad guideline of convenience and location. Subrule 2 says if that is the examination center, if a particular institution is an examination center, then permit the students take up the examination in their institution. Now let's consider in a slightly different field. One is fixation of the examination center. Other one is permitting the students of that institution to take up the examination in the same examination.
Yes.
This is what the rule provides. They cannot follow something of randomization still in terms of class 8 of this. That is now the lead to the whole operation of this. Has to be ignored and the other side of operation.
Yes.
And then next step. What is included in the legislative petition? The list of colleges which appears to have been published on 13/12/2022. That date your lordship may mainly mark it because any exercise which they want to apply to have been undertaken pursuant to the circular which they want to apply upon, that is an exercise which will have been undertaken by the 13/12/2022. Admittedly, this exercise is not carried out more particularly because clause 5 of the circular description says that ಇಪ್ಪತ್ತು ಪರೀಕ್ಷೆಗೆ ನಿಗದಿಪಡಿಸಲಾಗಿದ್ದ ಪರೀಕ್ಷಾ ಕೇಂದ್ರವನ್ನು ರದ್ದುಪಡಿಸಿದಲ್ಲಿ ಸೂಕ್ತ ಹಾಗೂ ವಿವರವಾದ ಕಾರಣಕ್ಕೆ ರದ್ದುಪಡಿಸಬೇಕು. ಅವಶ್ಯಕತೆಯಲ್ಲಿ ಮಾತ್ರ ನಮ್ಮ ಜಿಲ್ಲೆಯಲ್ಲಿ ಹೊಸ ಪರೀಕ್ಷಾ ಕೇಂದ್ರಗಳಿಗೆ So the mandate. Bangalore is a new city. Now, kindly have a look at the report which appears at page number 15.
51.
Page number 15, not of this the
memo.
Documents handed over to us by the you mark the date. I don't want to look at the contents. Feels into insignificance. Because this exercise, if you don't go it before 13/12, automatically my examination for my students. We have not excluded it. I was an exercise. Say that this is not an institution. They can make any number of allegations that you have noticed. Because the rule says wherever there is a requirement, so disqualification, examination staff, clause 15. I paid 44. Clause 23 and rule 23 speaks about disqualification procedures. So as the superintendent staff and the examiners are concerned. They are required to follow the law. There is a set procedure. They have either follow the procedure or not. Whatever they have now undertaken is a procedure which is foreign to whatever. They should not have selected their rules as a filter.
Without disqualifying you.
There is no order to disqualify. It is undertaken prior to 13/12.
Yes.
Therefore, the exercise should not be undertaken. Because I just want to read you A accreditation, A grade accreditation. One is our institution. We have a connection B. First is A grade accredited institution. Base 33.
Yes.
ಕರ್ನಾಟಕ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಮಾನ್ಯತೆ ಆಡಳಿತ ಮತ್ತು ಸಮಯ ಅನುದಾನ ಇತ್ಯಾದಿ ನಿಯಮಗಳ 2006 ಸಮಿತಿ Mediation with board to at least from 1968. One of the oldest institutions, the oldest institution in Badwal Taluk. And it's because in respect of a dated institution, it's not the state they should take because in respect of a dated institution, the instructions conducted in order to ensure that we adhere to all the standards with which we are required to function. Therefore, the system where they should not have taken this fact. They would follow the step for the purpose of nomination of the examination.
Yes, madam. Now, the fact remains that 2022, there is a center of examination. Factual points.
Examination.
Where is the distinction here? Are you disputing that the petitioner institution was a center in the earlier years and preceding? 2022 and prior, there was a center there in the petitioner institution. So all these years they were not permitted also. But there was a center for practicals.
Committee was submitted. The committee was much before the committee also has not. For looking of examination is done for every college. Every college. And we will differ based on which the APA of the district based on the fee. It is not be distinguished as only for generalization of this is the next. That is not only for the this point that they've already sent out on website. Which students we are in which one? The centers have been moved. And also the several repetition and single examinations. But you have to give some time to file objections, correction of mistake. Examination.
No, but why did you begin this? No, why did you begin this process of on 20th January after taking notice on 18th? You began this process and you have formulated this on the 20th of January.
This is only a report we have sought to create.
Now, when was the examination dates, other things published?
Where is the date on which the examinations are? It is taken prior to 30 months. Nothing is based on record to indicate that any exercise pertaining to this should be excluded or undertaken prior to 30 months.
No, the dates of the examination are announced on 1912 itself. Dates of examination.
Dates are announced on 1912. Now, dates of examinations. 13-1 is the date on which they have published the list of the examination centers. We gave a representation to them that these are the requirements. It's our institution and the examination center. But they gave an endorsement saying that we have concluded the process, we will not consider your request. I have placed it before this one the last year. That was after the filing of the reputation decision. That was on 17th, we might have 16th we received that endorsement. Saying that we have already, we are not considering the representation. The statement was made that our audit was stopped during examinations. For both the main examination and supplementary examinations, but theory examinations and important. They got a reason for rejecting this is not go for the
No, the rule 9 says change of center. Rule 9.
Yes, rule 9. I just read rule 9.
Change of center.
Yes.
Page 42. Page.
For the candidate to apply, page 42.
Yes, page 40.
Give examinations at the institution. In this last study, if it is made center or at the center to which the institution is attached, candidates may, in exceptional cases, seek change of center by filing application in such form as the business way, explaining the reasons for such change. This is an option given to the students to seek for change of center from one center to another center. But if you watch this scene, was 9-1, the first part of it. All the regular students and repeaters and examinations of institutions. This goes in validity 8-2. The exception is provided when they want to go to some other institution. That is an option for the candidates. There may be a circumstances where a candidate may be required. There is a prescribed one on the basis of which there will be the.
Yes, madam, how you can deviate this rule 8? Change it, who's stopping you? All right, but
practices of question papers, we had to redo the examination. So from then on, so far as theory examinations, we will not permit them to write in a specific college. They have to go to.
from when is this? But the theory, he has got the list of.
Examinations. The report also says the issue last year and conduct. In their own.
No, you may have a theory center.
Our institution, students, along with the students of about 600 students, for examinations in this center. Our institution students, along with the institutions of about 8 or 9 institutions, in all about 600 students, go the examinations in our center.
But,
Supplementary examination. Main examinations.
no, so what is this principle of main examination not permitted and supplementary can be permitted? You mean to say in the supplementary examination, there will not be mass copying or deviation?
Theory examinations, all process now is with respect to the main examination, theory and practical examination. The not theory my last year, students of the college. Nearby is happy. Yes, they did in their own
All. Yes, Mr. Ravi Shankar.
The nature of there's one. What they're doing. Change of examination is given. Allocate 200 300 students which are in the further box and monotonous. So attached to this. Because we have about 9 institutions that are attached to the previous year. I stand on this. For the year 2024, our center was designated and our students have taken up the examinations. Now, they cannot say that it's a current process. Not the nature of standard. Why I said,
That's correct. Rule of law has to be followed. Now the question is, does the state have the time now, and whether the students are going to be 6 February is next week.
Evening if they go, or they have to tolerate this. Yeah. I exams are not.
All right, when were you notified with regard to your institution not being there in the list?
Was notified. We gave a representation saying that we are already in the list. This was a representation which was submitted on 20th. And then the endorsement is issued. When they have a look at the endorsement, I am right along with the removal. Endorsement says since we have already undertaken the process, we will not consider it. On 20th of January, this request is made. But on 13/1, they have said, and this is what I have received along with the question cover I have used, which I have received on 19/1. What they say is that 2023 version in any what they do with this type of liberty, Allah is out of the our Jilla application. Like either like it, they give a representation because they have to be. This is the nature of endorsement. Scale of exercise has been undertaken by the they have changed the institution from one institution to another institution. Now the students will have to be notified during the date of the evening they can do it and then inform the institution. So the institution that this is the center. The examination system. That is where they are going to send it. Now they would not have wondered the question papers. I know how the bundling of the question paper is. They will be kept in 3 bundles and they will not indicate as to which is the bundle dispatch. One set of bundles they will dispatch it. So this is how this will be an exercise which you can undertake just 3 days before the entire exercise consists for the examination. I was recording the process.
Yes.
Immediately now we change
Correct, madam, but that cannot be a a reason or ground for you to deviate the rule of law. Yes. Then there is 8.2.
8.2 melons is a generality clause, not a mandatory. It's okay generally. Now, the entire thing, we have not amended. So, we are not making any college. Not they will not make all the examination, their own college. So, that's why now everything is.
All right. Anything else? I'll dictate the orders tomorrow. Heard learned senior counsel Sri Ravi Shankar on behalf of Gaurav GK, learned AGA for the respondents 1 to 4. Release this matter tomorrow for dictation.
Hearing matters. 47.
Yes. There is petitioner Jagdish. You are for? What is any urgency? What is this amendment? Grant of interim order of stay? Proceed. For what purpose was it recalled? Why is it restored? was initially challenged in the writ petition? Annexure E. That is. Suit got dismissed. Yes. What survives now in this? What survives when the suit itself is dismissed? No, all right, be the whatever may be the delay. Now the petition is restored. No, recalling was allowed the date earlier. Now it is restored. So if the main suit itself is no more in existence, what remains? So they have paid the deficit stamp duty and penalty also. The order was recalled on 30th/9/2022. There is no representation on behalf of the petitioner. The counsel for respondent number 1 is present. The counsel for the petitioner to answer as to what survives in the for consideration of the writ petition in view of dismissal of the suit. Suit is dismissed. Relist next week. ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ petition? All right, you go before the mediation now. All right, you go and try. You're resident of which place? Resident of which place? Hospet. And you are resident of? No, he is resident of? So for both of you, hospital be closer. It's the same thing you can do in hospital. Why you have to call her here? You are also in Belur, Hassan. Why? For settlement, why your senior is required? You can't appear before that court at the hospital. This petition is filed seeking transfer of the matrimonial proceedings filed by the respondent husband, pending on the file of Belur, Hassan district, to the senior civil judge Hospete, Vijayanagara district. Both the learned counsel submit that there is a possibility of settlement, and if the matter is referred to mediation center, they could work out the modalities. Mediation center at Hospeta. What is filed in the Hospet court? What have you filed? Where the proceedings under section 125 of CRPC is filed and pending. filed by the wife and pending adjudication. Both the respective parties are directed to be present before the mediation center and prospect on. When do you want to go? 9th or 10th? 10th February. 10th February to explore the possibility of settlement and report the same to this court. Is there any interim order? Interim order is extended till next week. Swami. Harish Bhandari. Transfer from? Harrier to Chitradurga. What is the distance? What is the petition filed by the husband? So you don't want to join your husband? You have not filed a petition for divorce. You are not filed for divorce. You want divorce? No, do you? We'll come to that later. Do you want divorce or you want to live with your husband? But provided is a big question mark between husband and wife. ಇನ್ನು ಯಾರಿಗೂ ಗೊತ್ತಾಗಿಲ್ಲ. Provided. ಪ್ರೊವೈಸರ್ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಪ್ರೊವೈಸರ್ ಇದೆಯೇನ್ರಿ ರವಿಶಂಕರ್ ಮದುವೆ ಆಗುವಾಗ? Provided you take care of me. Proviso. In no Hindu Marriage Act, Special Marriage Act, Christian Marriage Act, or under the Mohammedan law. Of course, in Mohammedan law, there is one meher amount fixed that you have to give back. Under the Hindus, even that is not there. So where is the proviso of provided you take care? It's all. Do you have any child? No. How old are they? 30 years and 25 years. Where is Mr. Harish Bhandari? All right, we'll hear him. Let him come. You want to pass over or you will have it next week? That counsel for the petitioner is present before the court. No representation on behalf of respondent. Let's release this matter next week. Nodi Matadi, you speak to Mr. Bhandari, whether if it is possible for him to take care of you and incorporate the provision of proviso next week. Interim order extended till next week. Alli Shantappa.
In this, my lord, I represent the respondent. Now here the case filed is in Udupi under for seeking restitution of coin.
What is this?
I mean, likely to be settled, my instructions, my lord.
Or it settle ಆಗ್ತಾ ಇದೆ ಅಂತಾರೆ.
No, there's a negotiation. That's what I was given to understand. I think Udupi mediation.
Settle ಆದ್ರೆ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಲ್ಲ ಅವರು.
Whatever.
ಏನಕ್ಕೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ತಾ ಇದಾರಲ್ಲ ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿ ಮಾಡ್ತೀರಾ?
Udupi, my lord, I filed a application for restitution of conjugal rights. Now that there is settlement for once for all, maybe for divorce also, so they would settle. So your lordship may kindly relegate us to Udupi mediation center. If doesn't happen, anyway, there is an interim order of stay already. Your lordship. Then we can, your lordship can consider for transfer.
From Udupi to Bengaluru. Respondent is staying in Udupi.
Yes, yes.
Arkala.
Arkala.
No, you are in Bangalore.
She has got her. Witnesses are there, my lord, and she has her own property there. And last resider also there only, my lord. So I don't think there is any impediment. So for one settlement in the mediation center, that if it doesn't happen, your lordship can consider.
All right, you come to Bangalore for mediation.
Again,
Lord Learned Counsel for the petitioner as well as Learned Counsel for the respondent. Both the party Learned Counsel submit that the parties are exploring the possibility of amicable settlement between themselves. Placing their submission on record, I deem it appropriate to refer this matter to Bangalore Mediation Center for resolution of the dispute between the parties amicably by way of mediation process. Accordingly, both the parties are directed to be present before the Bangalore Mediation Center on
second week of February.
9th February is okay?
Yes, sir. I'll convey to it. Yes.
On 9th February at 3 p.m. without awaiting any further notice from the school.
Yes.
Bangalore mediation.
Yes, sir.
What is your name? Registry to show the name of Learned Counsel Pramoda Gowda as counsel for respondent instead of Shravan Madhav KP as respondent has issued NOC in favor of Learned Counsel Pramoda Gowda and delete the name of Learned Counsel Shravan Madhav KP. Both the Learned Counsels are present before the court. Any interim orders there? There is stay granted. Interim order extended till next date of hearing. Relist next week. Week after next. Ganesh. Week after next. Stay extended. Yes, shall we transfer it? Huh? Transfer. She is a resident of Bangalore. So now she wants it in Chikmagalur because she is a resident of Chikmagalur. What is the distance? What is the distance? You obtained bail. It will happen. You obtained bail. Obtained bail. How they can do any illegal detention of you? The apprehensive can be there. Apprehension can be there. Transfer. How old? What is the child? How old? 1.5. Record. Oh no. The resident of Chikmagalur, why we should transfer it to some other place? Petitioner as well as respondent. Petition is filed by the wife seeking transfer of the matrimonial proceedings filed by the respondent husband. File of principal family court at Bengaluru to the family court. Family court is Chikmagalur, to the family court at Chikmagalur. Contention of counsel for the petition. The respondent husband has initiated a divorce petition under section 13(1)(1)(a) of the Hindi Marriage Act before the principal family judge at Bengaluru. And the petitioner wife has filed a criminal case for the offences punishable under section 498A, 307, 342, read with 34 IPC, and section 3 and 4 of the DP Act in crime number 121 of 2021, which is pending before the CJM, which is 307 CJM, which is pending in Chikmagaluru. It is also his contention that the petitioner's wife has filed a proceedings under section 125 CRPC against the respondent for seeking maintenance in criminal miscellaneous 136 of 2021, which is pending before the senior civil judge and CJM Chikmagaluru. Full stop. The petitioner also submits that from the marriage, a daughter is born who's in the care and custody of the petitioner, and she's residing with the petitioner at Chikmagaluru, attending to school. It is his contention that if by virtue of this divorce petition filed by the respondent, petitioner would be put to severe difficulty and hardship in view of the travel and the cost of accommodation, and she would have to leave behind the minor child, which would be detrimental to the interest of the minor child. Considering the fact of the distance travel and cost of accommodation and food, and so also the education of the minor child, learned counsel for the petitioner seeks transfer of this petition from Bengaluru, family court Bengaluru, to the family court at Chikmagaluru. It is also contended by learned counsel that no hardship would be caused to the respondent husband in view of the fact that 2 proceedings are already pending and he is attending court proceedings at Chikmagaluru in both the cases. Full stop. Taking all these into consideration and the hardship and inconvenience that would be caused, it appears the same weighs more on the part of the petitioner to travel from Chikmagaluru to Bangalore, which would be less cumbersome to the petitioner. Accordingly, the petition deserves to be allowed. Accordingly, I pass the following order. Petition is allowed. The proceedings in MC number 3216 of 2022, pending on the file of 6th Additional Principal Judge, Family Court, Bengaluru, is ordered to be transferred to the Family Court at Chikmagaluru to be tried along with, whether that is before CJM, to be tried by, to be transferred to the family court at Chikmagalur. Oh, Idyala. Present, learned counsel for the respondent, first sentence. Petitioner is present, respondent Natraj alla. Learned counsel heard, learned counsel Natraj, HC, and who vociferously objects to the transfer of the petition. Yes, Vijay Kumar. From Mangaluru to Hassan. Spastic. Yes, Mr. Pai. Thiruvananthapuram.
Distance from Dadar to Mangalore is about 8 kilometers. Distance from Dadar to Hassan is 388 kilometers. There is a difference of 30 kilometers.
Dadar to Mangalore is 418.
Dadar to Hassan is 388. Difference of 30 kilometers. Hassan is nearer than 30 kilometers. Now it is working at Dadar. Mangalore doesn't make any difference.
Junior resident psychiatry department. Then Mugudagutte. She'll complete the course in the medical college as a resident.
She's working there. Second department.
Correct. So Gadag to Hassan is 388 kilometers.
388.
So Gadan to Mangalore is 418 kilometers. So you're resident of which place? Hassan. What is the difference? What is the respondent doing?
I mean, general secretary.
So you used your surgical instruments on your marriage.
Yes.
And you are a doctor of psychiatry. Right. There is no possibility of settlement. Just file a petition for divorce. Correct. You're appearing for the husband. You want to join? You don't want to join? Husband. In Bekantanim. What your client wants? So you don't want divorce or you want to join your husband? Don't want to join. And you see settlement. Correct. You go before the court for mediation first. Instead of all this circus of transferring. Yellow. Huh? Mediation go okay. No need to talk to counterpart. You go for mediation. If they are able to convince you to join, you join together. If both of you are adamant, then you separate. You can concentrate your time on surgery and psychiatry rather than experimenting on each other. Hasan. Already you come to Bangalore mediation, both of you. But good. Heard the learned counsel, the petitioner Vijay Kumar T and learned counsel Sri M. Sudhakar Pai for the petitioner and respondent respectively. After hearing the matter for some time, would the learned counsel submit that there could be a possibility of settlement? The matter is referred to mediation center. As both are qualified doctors, it is better they make an effort to resolve their dispute before the mediation center.
I am open advocate in Bangalore. Mediation let them go on 3 hours.
Asan to Bangalore. Come to Bangalore again, that's a question, a big question mark. We both the parties are directed to appear before the Bangalore Mediation Center, which is a neutral place for everybody. Bangalore Mediation Center, when you will come on 15th February, or you want earlier? T8 will be too close because your counterpart there will have to communicate and both are doctors. They may have to find time, take out the suitable day off. 28. Okay. 28th Saturday. ಬೇಗ ರಿಸಾಲ್ವ್ ಮಾಡ್ರಿ, ನಿಮಗೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳಂಗಲ್ಲ, ಅವ್ರ ಲೈಫ್ ಆರ್ ಇಂಪಾರ್ಟೆಂಟ್. You see, on 28th, if you can't come, then you take one more day. On 28th January at 3 p.m. both the parties shall appear before the Bangalore Mediation Center without awaiting any further notice. They are at liberty to be accompanied along with their family member. Illa. Then you go on the week after that. 4th February. 4th February. Interim order is extended till next date. ಅವ್ರ ಹತ್ರ ಇದೆಯಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ವಾ? ಇಲ್ವಾ? At the request of learned counsel for the appellant, release this matter next week. 60 under? Ah. 60 at request of learned counsel for the insurance company. Next week.
Serial number 56. Steps.
Okay. On behalf of? Yaru. At request of appellant, release this matter next week.
Serial number 56.
2014 ಎಲ್ಲ ಏನಿದೆ then ಅರ್ಧ ಗಂಟೆ ನಿಮಗೆಲ್ಲ ರೆಡಿ ಮಾಡ.
Serial number 56, my lord.
Serial number 56, what do you want, madam?
I will take steps to the insured, my lord. ಇದನ್ನ third time ಹೋಗಿದೆ ಅದು.
ಯಾರಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
ಅದರಲ್ಲಿ we have challenged liability, my lord.
No, in the other case they have not appeared.
ಇಲ್ಲ appear ಆಗಿಲ್ಲ, ಅವರು dispense.
Request of learned counsel for the
I will take paper publication, my lord.
Appellant in MFA 1810 relist after 1 week.
ಆಯ್ತು ಸರ್, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೋತೇನೆ.
All right, ತಗೊಳ್ಳಿ, relist next week.
Serial number 55 we have ready.
55, yes?
Ready ಇದ್ದೀನಿ ಅವರೇ ಮಾಡ್ಕೋಬೇಕು.
All right, you come and argue. Yes, 71. At request of counsel for relist week after next. Why? Who are you? Why? Why? Henry inconvenience 2014, 10 years. You have not read the file. ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಪಕ್ಕದಲ್ಲಿ ಇನ್ನೊಂದು you will have continuously other cases. Request of appellant relist next week as a last chance. Yes. 45. 45 is called out. 45, 54, you're not sure. 54. Adiwal. What do you want? You're ready? Then you wait, madam. It's 1:37. It's lunch time for me and my staff and for you also.
సైలెంట్గా కొట్టానే చెప్తే అయితుందంటే అయితుందని లేదంటే లేదన్న అగో ఫోన్ పే అగో గూగుల్ పే అగో ఫోన్ చెప్పనుండమ్మా చెప్పినాకేమంటే వద్దా మాట్లాడలే ఏమంటే వద్దా మీ చూడాలి అంజలంటే నీ అంటే కూర్చోని చెప్తున్నాడు అనంతరం దురాగరం కదమ్మా అంతే వాళ్ళు చేసింది దురాగరము ఎవరెవరు కాసుపడుతుంది ఇగో మన గుర్తు మనమే పడలేదమ్మా అందరు జనాలు కన్యక
మ్యూట్ ಮಾಡ್ಕೊಳ್ಳಿ ರಿಯಲ್ಮಿ Matter pertains to Harvard bench. Hearing on IAS number 1. Take the chinma.
I have a petitioner in this stage, my lord. For application for correction of the judgment order, my lord. There is a typographical error in the survey number, my lord.
So how you can file an IA? You can file an IA for correction of a judgment. You have to make it as for being spoken to.
My lords are sitting in. Therefore, there is a typographical error in the already.
How this court can entertain an IA in a disposed of petition? Yeah, what are you seeking here?
The correction of survey number, my lord.
Then that has to come as for being spoken to.
Then it may be
not IA. Oh, IA objection raise module registry. Call the registry. Oh. Just check up with somebody here. Oh, make a call. Which is the survey number that needs to be corrected?
Survey number, my lord, in the
to be corrected is 43A413.
43 bar A bar 4 bar 13 came around.
Instead of 12, it has to be 13.
Yes, my lord. And the page number 2, 3, and 6, my lord. There is a wrong entry.
Page number
2 at bottom, my lord. At bottom, my lord. 43 bar A bar 4 bar 12 is there.
What is the judgment? Who's the other side? That's the government.
Government.
Who appears?
I served a copy to the government already.
There is a judgment. Where the correction has to take place? In the
operative position also, madam. And
then?
And page number 2 at bottom, madam, and page number 3 at first paragraph.
Page number 2.
Page number 2 at bottom, madam. Survey number is bearing survey number 43 bar A bar to 13. It must be 13K, madam. Instead of 13, it was we had 12 only.
Page number 2, then page number 3 also.
Page number 3, there was mistake in 42. Instead of 43, it was 43. 42 I told them. 43 bar A bar 4 bar 13K.
Bar A bar 4 bar 13K.
K. And also at our page number 6, my lord, at operative portion. It also
13K.
Same 43. 43 ಆಗಬೇಕು 42 ಆಗಿದೆ 43 ಆಗಬೇಕು.
No, 43 ಆಗಬೇಕು.
43 bar A bar 4 bar 13K.
That's all.
Yes, that's all.
3 places. Page number 2, which is the prior to the judgment portion, and in the order portion in first para, that is 43 bar A bar 4 bar 13K instead of 42. Correct?
Yes, ma'am. Yes, ma'am.
Where have you said it that your petition survey number is 43 bar A bar 4 bar 13C?
Produce record of right, ma'am. Page number 44, my lord.
No, record of rights you may produce, but what is the prayer you have sought? And what is the first para of your writ petition? What have you stated in first para of your writ petition?
It was 43 bar A bar 4 bar 13.
And then who's at fault?
It's our fault.
Where will you produce record of rights?
Page number 44, my lord.
You have made some corrections in your prayer also by incorporating some corrections, which is not forthcoming in the order sheet of the court.
The same, sir, 43 bar A bar 413 instead of it has to be K, 13 K.
Where have you produce your record of rights?
Hello? Page number 44 is there, madam.
Where does it say in page 40?
43 survey number is 43. Hissa number A bar 4 bar 13 ka.
Which page number 44?
Petition copy, madam.
Page number 44 is some deed.
No, it is record of rights, madam.
Page 40?
4, madam. 44.
No, it's not record of rights.
In my page, madam, it is 44, madam.
What is this? Which annexure is it?
Annexure D series, my lord.
There is no page 44 is after Wakalat. Annexure D series.
Yes, ma'am.
Annexure D ends in page 30. D and D1. With the government, there is no representation on behalf of respondent state. Learned counsel for the petitioners present. Yes, this back next week.
Yes, ma'am.
Yes. 31st.
Yes, ma'am.
Get the government on that day. He has
Yes,
to
ma'am.
stay. If he has any objections or.
Yes, ma'am.
we have started. Serial number 55, huh? For available.
Number 54.
Use the mic, use the mic. You can pull it to you. You can need not go that side. One from Kolar to Bangalore. Section 9 petition is filed by your husband, your client's husband. So he doesn't want to join him. Further. Leonard Council. Huh? Who's defendant? Maguge. Leonard Council for the petitioner. Issue notice to respondent. Counsel for the petitioner is permitted to take out notice to the counsel appear representing the respondent before the senior civil judge and the principal JMFC. Not to jail. Orders on I1. There shall be stay of further proceedings in MC 19 of 22, pending on the file of principal additional senior civil and judge JMFC KGF till next date of hearing. Chetan, you are Venkatapati, you are ready? You are Venkatapati. You are not Venkatapati. You are able to hear me? All right. You are appearing for whom? Whose R2? Insurance. Liability is on you. No need of R1. R1 is owner. Your claimant. Enhancement. Argue. Yes, you can argue. Understand? How much is taken per month? 30. So 2,500 is taken. That is 2,500 per month. What is the bills you have produced? Does it show any amount? Your records it here. Check which one? How much you spent vending as per P7? So what is the highest? 3,800.
Also calculating the reduced fee RT.
What is the year of accident?
10.
What is taken by the tribunal? 30,000.
After direction,
It's a case of injury. What is the age? 40. Not disputed. Not disputed. So tribunal has taken 40. Multiplier will be 15. Yes. What is the chart income? Chart. Already. 40 years. Take this. How much is the future cost? I will take. You should take this out to this. What are the future prospects? That is below 40. You are 40. Then you, how much should be given? How can you be given 40%? 25%, brother. Yes. Separate party. Where is the discussion of the trial tribunal with regard to income? Page 14.
This is for bringing meat to Marna meat dairy. The conditions of this meat are issued by Marna dairy. Separately, Marna
Yes. So you are satisfied if 7,000 rupees is given as income? So we'll take it 7,000 income plus future prospects. 40%. Huh? What about consortium? Consortium. This Jana idhar 5. Huh? Huh? So you don't want for 2 and 3. You don't want. Have you read the judgment of Supreme Court? Which judgment have you read? Not read. Magma Pranay Sethi. What happens to Birender's case and Satinder Kaur? He may not be aware, but the court cannot do injustice, even if he doesn't argue and if he doesn't know the law. You're not read. Why do you argue then when you are not ready? You should read and come. Legal representatives are entitled, that is decided in Satinder Kaur, Birender's case. Perfect. That's all. You have anything else? That's all? Perfect. The appeal is preferred by the claimants seeking challenging the given judgment and award passed by senior civil judge and MA City Holinar Sipur dated 23 day of November 2012 and MVC 391 of 2012. The appeal is premised on the ground of inadequate and meager compensation awarded by the tribunal. Parties to the proceeding shall be referred to as per their rank before the tribunal. Matters listed for admission. So the matters listed for admission, consent of both parties, matters taken up for the final disposal. Brief facts of the case on 10th March 2012. As per code. Listen. On service of notice, a respondent appeared before the court and objected by filing statement of objection and denied the contents therein. And sought for dismissal of the claim petition. On the basis of pleadings, tribunal framed relevant issues for consideration. In order to substantiate the issues and establish the case, the claimant got examined as PW1 Claimant number 1 got examined as PW1 and got marked exhibits 7 P1 to P17. Full stop. Claimant also examined PW2 in support of their case. On the basis of material evidence, both oral and documentary, the tribunal granted a total compensation of, allowed the claim petition granted compensation of 4,80,000 along with 6% interest the date of petition till realization. Full stop. Agreed by the meager amount of compensation, claimant is before this court seeking enhancement. Full stop. Is a vehement contention of learned counsel for the appellant claimant that the tribunal has committed an error in not awarding just and reasonable compensation and has not considered the material evidence, both oral and documentary, in award of compensation. He further contends that the income adopted by the tribunal is on the lower side. The tribunal is not taken into consideration award of future prospects. And so also the consortium is not awarded in accordance to the well-set guidelines and the precedents of the Honorable Apex Court and this court. On these grounds, he seeks to allow the appeal and consequently enhance the compensation. Per contra, learned counsel appearing for the representing the insurance company vehemently objects to the arguments put forth by learned counsel for the appellant claimant. Stop. He sustains the order of the tribunal and contends that as there was no material evidence placed on record with regard to income, tribunal is right in assessing the income at 30,000 per annum, which does not call for interference. On these grounds, he seeks to dismiss the appeal. Having heard learned counsel for appellant and the respondent, the point that arises for consideration is whether the claimant is entitled. Claimants are entitled to enhancement of compensation. Stop. What order? It is not in dispute that on 10th March 2012, when the deceased Shankare Gowda went to Chandrayapatna for vending coconuts at about 7 to 7:30 p.m. At that time, along with one Kumaraswamy on the motorcycle. At that time, another motorcycle bearing number KA54E 5397 came in a rash and negligent manner, dashed against the vehicle being ridden by Kumaraswamy, in which the deceased Shankare Gowda was a pillion rider. Huh? Kumaraswamy ಅಂತಿದೆಯಲ್ರಿ. Devraj is the offending vehicle, I say. The occurrence of accident, involvement of vehicle, and the death having occurred due to the accident are all not in dispute. Same need not be adverted to at this point, as the liability and the accident is not questioned by the insurance company or owner of the offending vehicle. Exhibit P1 to P17 are the documents which are exhibited, which are police records as well as the medical records and the documents to show the income. Same establishes rash and negligent riding by the rider of the motorcycle and charge sheet having been laid against the rider of the offending vehicle, that is motorcycle, which is not questioned. Now coming to the aspect of age, avocation, income, and quantum of compensation. Age of the deceased as on date of occurrence of accident was 40 years, which is not seriously disputed. The same is taken on the basis of, the postmortem report. Age is taken as 40 years on what basis? Which is not disputed. Which is not disputed. Future prospects has not been awarded by the tribunal in view of deceased being aged 40 years. 25% would have to be awarded as future prospects. Full stop. Though the claimants have produced exhibits P8 to 13 and P14 to 17 to show that deceased was doing milk vending business and was doing agriculture work, nothing concrete has been placed to show the proof of income cogently. However, exhibit P8 to 13 depict that he was vending milk and earning about 3,750 per month for several months. Apart from that, it is to be seen that the deceased was involved in agriculture work. When there is no clear proof of material evidence with regard to income, the notional income chart of the Legal Services Authority prescribes income for the accident year 2012 as 7,000 per month. Same is taken as income in this case. What is the deduction that is taken by the tribunal? Huh? On what basis? Which paragraph? So 1/4 will have to be deducted. All right. Have you done the calculation? Just work there. What is the calculation? Just work there. If income is taken at 7,000 per month, 25% will have to be added towards future prospects, which would be 8,750. 1/4 will have to be deducted towards personal and living expenses in view of there being 5 dependents. So 8,750 divided by 1/4 is 6,563 into 12 into 15. The 11 lakhs 81,340. $11,81,340, which should be the amount towards loss of dependency. Tribunal is not awarded suitable amount under the head loss of consortium and under other conventional heads. There are 5 dependents, being the wife, 2 children, and aged parents. So each of them will be entitled to 40,000 per head in view of The judgment of Apex Court in the case of National Insurance Company versus Pranay Sethi, followed by Magma and Satinder Kaur, and so also Birender's case. The 40,000 into 5, 2 lakhs is awarded under this head. Towards funeral and obsequies, 15,000 is awarded. Towards loss of estate, 15,000 is awarded. Under conventional head, 2,30,000 is awarded. In view of the judgment of Apex Court in Pranay Sethi, 10% would have to be awarded towards one block period. Accordingly, 10% of 2,30,000, 23,000. Let's take the total. $1,434. Straight. 1434, 340. Record. Slow, madam, you would be fast. 14,34,340 as against 4,80,000. In view of the above discussion, claimants are entitled to total compensation of 14,34,340. Accordingly, I pass the following order. Appeal is partly allowed. Judgment and award passed so-and-so is modified. Claimants are entitled to so-and-so as against 4,80,000. The judgment is set aside with regard to dismissal as against petitioners number 213, claimant number 213. And they will also be entitled to the apportionment of compensation. The respondent number 2, insurance companies, is liable to make good the compensation from the date of petition till realization at 6% interest. Same shall be paid from the date within a period of 6 weeks from the date of receipt of copy of this order. Petition number 1. Whether the parents are still there. Apportionment 10% to all of them and remaining to the wife. Oh no, wife will get more shares, sir. 3%. 3%. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಹೇಳೋದು ಇಲ್ಲ. All right, 60%. Now that goes, Mr. Because of petitioners number 2 and 3, now we are including them. No, they will get others also. So 60%, but the apportionment shall be made in the following manner. 60% of compensation shall be awarded to the claimant number 1, wife, the widow of deceased. And 40% shall be equally distributed between the parents and the %5 ಮಾಡೋಣ. They are major ಅಲ್ಲ adults. Adults ಅಲ್ಲ ಅವರಿಬ್ರು. All right, make it 30% to the parents and 5% each to the No, you can assist the court. All right. So what is 5% of 71,000? So okay, we'll make it 5%. 5 plus 5, 10. Plus 20%. 10. 70% to the widow. 70% to the widow. 10% each to the aged parents, that is mother and father of deceased. 5% each to claimant number 2 and 3, that is, they are the brothers, huh? Sons of the deceased. 5% each to the claimant number 2 and 3. So thereby 70% major portion goes to the wife. You are standing blank. Out 70% aitalla, whether parents are surviving. ಯಾವಾಗ ನೀವು ಫೈಲ್ ಮಾಡಿರೋದು petition? What is the age? What is the now age? 10 years. They are 75 and 70 years now. Should come read, sir. Don't come unprepared to the court. No, come on the question of law. Read the papers, read the judgments. Don't come to court without reading. Seven. Divakar. Is he a friend there in the screen? Not there. Ilva. Albara, idella baralla. Image. You can see yourself. Yes, E.R. Divakar. You are appellant. No, Divakar is not here. R2. E.R. He is for insurance company. Is a death case. What are you challenging? On what grounds? Medical expenses from the water. And the tribunal has taken who is the person who died? Son. What was this? Son of the chief widow also.
The claimant, before your lordship is said to.
ಯಾರು ಚಂದ್ರಕಾಂತನ? ಚಂದ್ರಕಾಂತ?
Yes, my lord. Chandrakanta died, my lord. I am for R2. I am for R2, my lord.
Sir, we are calling you from that time and you are not
No, my lord,
available.
I'm rising. Some problem in the this one, my lord, in the video.
Now, are you able to hear Mr. Bhatt?
No, my lord, I'm not able to hear.
Michael Mata. Because he is in VC, he can't hear you. You have to speak on the mic.
Yes.
So good. You are lucky your friend is here.
I'm waiting for the morning, my lord.
All
Pray for
right.
the morning, I'm waiting.
Doesn't matter. Yes. So Chandrakanta died. What was his age?
Was aged 33 years or 34 years.
Any dispute on the age?
So far as it is concerned, there is nothing.
What have you produced?
That is I have the ration card and
Risha मुझे इतना बोला.
Marks card ಎಲ್ಲ ಯಾರ್ದು? Ration card which exhibit?
ration card.
11.
Notice copy of the ration card.
All right.
And it will disclose the age of mother and some both.
All right. 30.
Now the age of the mother. That is wrong. One thing. And it should have taken the age of the deceased. Then the
16 would be the multiplier.
60.
Income.
8,250. He was working in Maruti Matrimonial Motor. I have examined the sales executive to prove that he was working and also to the salary certificates. And therefore the tribunal has taken into consideration. Income as 8,200.
Exhibit. P10.
P10 is the salary.
Whom have you examined? Whom have you examined?
I have examined the representative of the Matrimonial Motors.
Jagdeep Rai.
Jagdeep Rai. He has categorically stated that his income and also produced the salary sheet and other salary documents.
That is accepted? Not accepted. Accept. What is the salary?
8,250. But I am entitled by virtue of the of the maritime insurance and safety of the for the future prospects. So for the
income, first let's come to income. 8,250.
the salary certificate, that is the
Private.
monthly salary 8,250. For that, he was also getting the benefits of 3,000, 4,000 and all. That is the added as per the scene from the NBC exhibit P10 for the moment.
Yeah, my records. Where are you paying income tax?
They have previous money that 46, 10% every month. Previous again of them. He was getting salary 8 and above 8,000. So for the remaining portion is just not paid.
2,000. Three 13,712.
Deducted 50%. That is correct. Because you are the doctor and you home mother. 50% 50% deduction saving.
No, that average incentive of 5,000, it's an incentive.
Sufficient incentive, he was not paying income tax.
The incentive is a variable, it is not fixed. Incentive andre ಏನು ಗೊತ್ತಿದೆಯಾ?
No, sir, because the work what he has done, that is right was. I know that.
So that is
Sufficient is that salary is not at all, there is the less than 8,000.
all right. Anyway, tribunal has taken 8250. All right. All right. Next. I to come to the next point. Yes, too. Adenge.
Fixed salary person is getting fixed salary.
What is it? P10. Mandovi Motors.
Is not being 2014.
You will not get 50%. 50% is for permanent job.
40%. No, it is a job is permanent, but it is in a private company, not in the government.
Permanent job has to be, you'll be getting 40%. That is a classification. Yes, next. The chart ಮಾಡಿದೆ.
5,000 was awarded because the
Chart ಮಾಡಿಲ್ಲ. Tribunal has not prepared a chart.
No, chart has not prepared.
So no, estate ಕೊಟ್ಟಿಲ್ಲ. Yes, sir. That's all.
My lord, exhibit P20 may kindly be seen, my lord.
What do you mean?
That is the salary, serial number 44. He was getting 8,350 only. Exhibit P20, my lord.
Yes, to 8,000?
350, serial number 44, 8,350, my lord. That was the total earnings during that particular point of time. Serial number exhibit P20, serial number 44. His name has been mentioned.
So the tribunal also has taken 8,350.
Please, my lord. Yes, my lord. Yes, my lord. Yes, my lord. And the age of the
one nimsha. Serial number 44.
Yes, my lord. Serial number 44.
8,350. He's also claiming the same. We will go by that.
Okay, no dispute, my lord. No dispute. And the age of the mother has been taken as a 62, my lord.
P21 is 8,350. We'll go by that.
Yes, my lord. And the age of the mother has been taken as a 62, my lord, instead of 57.
No, where's the question of taking the mother's age for calculation?
Because that's a claimant age.
Yes. Claimant age, right? Deceased age tagobekalla.
Yes, yes, true, my lord, true. The age of the deceased has to be taken. Yes, well. Yes, my lord. This only to two submissions, my lord. The estate has not been made.
The consortium and estate has to be given.
Yes, but it's not been, but it has to be given, madam. It has to be given.
In the judgment. That's okay. Not required. ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಹೇಳ್ಬೇಡಿ. Which is that judgment?
Alliance Insurance Company versus Yodagiri Group and another.
ಯಾವ High Court of Karnataka? Take it. That's all. No, ಬರ್ಕೊಳ್ಳಿ. Yes, pick down. Appeal is preferred by the claimant, agreed by the given judgment, so on, so on, so. Brief facts of the case, so on, so. The vehement contention of learned counsel for the claimant that the tribunal has committed a serious error in not awarding just and suitable compensation and has grossly erred in taking into consideration the age of the mother for calculating the compensation and multiplier. He further contends that the tribunal has lost sight of the fact that the future prospects has lost sight and has not awarded future prospects as the deceased was aged less than 40 years. And also the tribunal has not awarded compensation towards consortium and other conventional heads. On these grounds, he seeks to enhance the compensation, allow the appeal and consequently enhance the compensation. It's the vehement contention of learned counsel for the insurance company, respondent number
R2, Miller.
That the
Respondent
judgment
number 2.
passed by the tribunal is just and reasonable as per the documents, both oral and documentary produced by the claimants, and he sustains the order passed by the tribunal as being reasonable and seeks to dismiss the appeal preferred by the claimant. Having heard learned counsel for both the parties, the point that arises for consideration before this court is whether the tribunal has committed an error in awarding meager compensation and whether claimant is entitled to enhancement of compensation, what order. It is not in dispute that the accident occurred on 10/6/2011 when Chandrakanta K was standing on the extreme left side of the road in front of Mandovi Motors, Ampandakatta, Mangaluru. Ampandakatta, Mangaluru. At that time, auto rickshaw bearing number KA19A4596 came from Ambedkar Circle in a rash and negligent manner so as to endanger human life and safety and dashed against the said Chandrakanta K, who sustained serious injuries and despite being admitted immediately to KMC Hospital, Mangalore, succumbed to the injuries on 9/7/2011. Full stop. It is stated that claimant was hale and healthy prior to the occurrence of accident. He was working as an assistant manager of accessories in Mrs. Mandovi Motors, Mangalore, earning a total salary of rupees 13,712, for which salary certificate has been produced at Exhibit P10. And the claimant has examined PW3, the employer who was
College lecture.
PW3 and Takidira Nivu. You have stated PW3. PW4, the employer who has reiterated the employment of deceased and the salary which was drawn by the deceased. Full stop. The occurrence of accident, involvement of vehicle, deceased having succumbed to injuries due to the accident are all not disputed and not questioned. Claimants have produced Exhibit P1 to P27, which are police records, the medical records and proof of salary, age, and other relevant documents pertaining to the accident. The respondent has stepped into the witness box not stepped into the witness box, but however got marked exhibit R1 to R5. The insurance policy is produced at R4, which is in subsistence. In view of the production of the exhibits P1 to P27, there's no dispute with regard to rashness and negligence on the part of driver of the auto rickshaw and the insurance policy being in force. The second respondent insurance company is liable to make good the compensation. Now coming to the aspect of age, avocation and income of deceased. Deceased was aged 33 years. The income is taken by the tribunal at 8,350 as per exhibit P21, which is accepted by the tribunal. The tribunal has failed to award 44 future prospects, and in view of the fact that the deceased was in a employment of a private company, well-established private company, namely Mrs. Mondovi, is entitled to 40% towards future prospects. And since he was aged 33 years, the appropriate multiplier would be 16. The tribunal has committed an error in calculating the multiplier on the basis of age of the claimant, that is the mother of deceased, which is not correct. The same is erroneous and it is set aside. The income is taken as 8,350. He was unmarried?
Yes, but he's a bachelor.
Huh? Yes. In view of the fact that the deceased was unmarried and has left behind only his aged mother, 50% will have to be deducted towards his personal expenses and personal and living expenses. 11,690 being the income minus 50%, 5845 to 12 into 16.
But 8,350 is income.
Fine. Into 12, 16. 11,22,240 could be the amount of compensation under the head loss of dependency. The tribunal has not awarded suitable amount under the head consortium and towards loss of estate and funeral expenses. Consortium kottidara love and affection 50.
50 funeral 5,000 is awarded.
Love and affection is awarded 50,000, same is retained as consortium. Towards loss of estate and funeral expense, nothing is awarded. Towards funeral expense, 5,000 is awarded. In view of the judgment of the apex court in the case of Pranay Sethi stated supra, claimant should be entitled to 15,000 under the loss of estate and towards funeral expenses 15,000. In all 30,000 as against 5,000 awarded by the tribunal. Medical enilala. But you have not placed anything.
All the medical has been given by the ESM, madam.
All right. So now claimant is entitled to compensation of rupees 12,02,240 as against 4,05,700 awarded by the tribunal. As per the table mentioned here and below. Accordingly, I pass the following order. Appeal is partly allowed. ಎಷ್ಟು ಕೇಳಿದ್ರಿ ನೀವು claim petition ಅಲ್ಲಿ? This is more than that. No. How much you claim?
12 lakhs, my lord.
12. ಎಷ್ಟು ಬರ್ತಾ ಇದೆ? Appeal is allowed, not in part. Appeal is allowed. ಅದು ನಮಗ್ ಬೇಕು. Partly allowed or allowed ಬರ್ಬೇಕಲ್ಲ. Now it is allowed. The court has the power to grant more than what is claimed. Conventional head ಅವ್ರು ಕೇಳಿಲ್ಲ ಭಟ್ರು 10% as per chronicity on the conventional head. ಬರುತ್ತೆ ಅದು 40 plus 50 plus 30 80 8,000 rupees. Appeal is allowed. Judgment and award modified. Entitled total compensation of so as against so.
My lords, kindly.
To insurance company shall pay the entire compensation on the date of claim petition till realization with 6% interest. Yes, sir.
My lord, the salary as income has been taken as 11,690, my lord, but it is only 8,350, my lord.
Plus 40% ಬರ್ಬೇಕಲ್ಲ, Mr. Prabhakar.
Okay, my lord. Yes, my lord. Yes, my lord.
Plus 40%.
Yes.
Minus 50%.
Minus 50%. Yes, my lord. Then it comes to 11,600. Yes, my lord.
No, it doesn't come to 11,690. It comes to 5,845. Plus 40 minus 50.
Yes, my lord.
ನೀವು ಹೇಳ್ಕೊಡ್ಬೇಕು ನಮಗೆ ಏನಿದು ಮಾಡಿದ ಕೆಲಸ.
Yes, my lord.
ನೀವು ಹೇಳ್ಕೊಡ್ಬೇಕು 16. The entire compensation amount shall be paid within a period of 6 weeks from the date of receipt of the copy of the order.
Please, much obliged.
58,
Well, I am for appellant, my lord. The my lord, case of injury, my lord, the main contention in this appeal is, my lord, there's a two vehicles involved. I'm the pillar rider of TVS, and another vehicle lorry is dashed. My lord, the negligence aspect is decided 60% on the TVS where I was proceeding and 40% on lorry. My lord. Both the vehicles made as party.
No, who was preferred this appeal?
Claimant.
You are claimant?
Yes, I am claimant. My lord, I am the pillar rider of TVS, which is held as 60% liable. And since the driving license not produced, the company is exonerated from payment of compensation. And as far as 40% negligence on the lorry is concerned, they satisfied the award. They are liable only for if any compensation is enhanced. But as far as this TVS is concerned, since the driving license is not produced, only on presumption, the company is exonerated. But I can't argue on that point. Only pain recovery na helbodu, because owner is I am representing only claimant.
TVS insurance company yaudu?
TVS is 3 and 4.
Who appears?
Pradeep is appearing.
You're appearing for TVS insurance company.
That pay and recovery the sacks.
4. So 3 is the owner.
Owner, 4 is the.
Yaru? That is the lorry. That is
1 and 2. Keshav Prashant is the printing. They are admitted the liability. There is no dispute on that point. In the strict sense, my lord, that actually exoneration of insurance company is not proper, because only on presumption, my lord, these since the driving license not produced, company the owner.
So against you, it is dismissed.
Yes.
Because the driving license was asked. So that is no more good law.
Malad, may I come to that point, Malad?
Yes.
Quantum ಬೇರೆ ಯಾವುದು enhancement ಇಲ್ಲ some. Future loss of future loss ಅಲ್ಲಿ. Malad, she sustained fracture of right humerus and right ulnar temporal subjugal hematoma and severe head injury. Malad, 1,14,000 the medical bills of 4 days inpatient. Malad, future loss, Malad, 15.4% whole body, and there is a specific evidence of the doctor.
Is the treated doctor? Is he the treated doctor?
Malad, this treated doctor theory, Malad, is not so much nowadays. Malad, there is some judgment which is yes, he's a treated doctor, Malad, PW2. Treated doctor.
15%.
15%. Others ತಗೊಂಡು ಆ ವರ್ಷ 2011 ಅಲ್ಲಿ ಬಹಳ ಕಡಿಮೆ ಇದೆ ಅಂತ ಕಾಣುತ್ತೆ. ಅದರ್ಸ್ ತಗೊಂಡು ಮಾಡಿದ್ರೆ ಸಾಕು. One head is covered. Future loss. 2011
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು
ತಗೊಂಡಿಲ್ಲ ಕೊಟ್ಟೇ ಇಲ್ಲ. ಸ್ಟೂಡೆಂಟ್ ಅಂತ ಹೇಳ್ಕೊಟ್ಟೆ.
So tribunal has rejected.
Rejected. Not considered. Well, 6,500 ಆಗುತ್ತೆ. 2011 age is 21. So 18 is the multiplier. 15% ತಗೊಂಡ್ರೆ 6,500 into 15% ಅಂದ್ರೆ 975 ರೂಪಾಯಿ 975 rupees per month into 12 into 18 ಮಾಡಿದ್ರೆ 2,10,600. ಅದು ಒಂದೇ ಮೇನ್ ಹೆಡ್ ಸ್ವಾಮಿ. ಉಳಿದಿದ್ದು ಯಾವುದು ಟಚ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ. ದೇ ಸಫಿಶಿಯಂಟ್ಲಿ ಕಾಂಪನ್ಸೇಟೆಡ್. ಲಾಸ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಡಿಸ್ಫಿಗರ್ಮೆಂಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆದ್ರಿಂದ ಇದು ಒಂದೇ ಹೆಡ್ ಟಚ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ ಸ್ವಾಮಿ. ದಟ್ ಇಸ್ ಬೆಟರ್.
So that is loss of income.
Future loss of earning and earning capacity.
Income due to disability.
Yes. Only one head and liability as far as 3 and 4 is concerned, company held liable, pay and recovery ಮಾಡಿದ್ರೆ ಆಯ್ತು. For enhancement, same ratio. 40 is on Keshav Prashant and 60 is on Pradeep.
What is the income?
6,500 ತಗೊಳ್ಬೇಕಾಗುತ್ತೆ 2011 chart as per chart.
What was the boy doing?
Diploma student, 21 years.
21 years. 6,500.
House.
Age 21, no?
21. 18 is the multiplier. 15% loss of earning capacity.
All right. Yes, Mr. Keshav Prasad.
I called him. He assured me to attend the court. ಇದರಲ್ಲಿದ್ದಾರೆ VC ಇದ್ದಾರೆ. ಕೋರ್ಟ್ ನಂಬರ್ 28 ಅಲ್ಲಿ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
He is here. ನೀವು ಸ್ವಲ್ಪ ಸಮಯ ಕೊಟ್ರೆ ಅವ್ರ ಮಾತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಹುದು.
ಮಾಡಿ.
And have no issues, my lord, as far as the negligence aspect is concerned. Lord, as far as the loss of future income is concerned, my lord, diploma student, 3rd year, 6th semester diploma engineering. Income
ಜಾಸ್ತಿ ತಗೊಳ್ಬೇಕು ಅಂತೀರಾ?
ಎಷ್ಟು ತಗೊಳ್ಬೇಕು?
Loss of academic year ಏನಿಲ್ಲ. That was also my lord considered.
ಟ್ರಿಬ್ಯುನಲ್ ಏನು ತಗೊಂಡಿಲ್ಲ. ಎಷ್ಟು ತಗೊಳ್ಬೇಕು ಅದನ್ನ ಹೇಳಿ.
Loss of amenities ಅಲ್ಲಿ ಜಾಸ್ತಿ ಮಾಡಬಹುದು, because future loss of earnings my lord has to be calculated based on the my lord income.
We are going to, this court is going to assess his income now.
That is the
Yes, you can argue why I should not assess the income of
a student, because she is continuing in studies. There was no loss of academic year. She has completed her diploma. So all those things are there. So, my lord, in my opinion, my lord, she might have joined some other company and she would have earned handsome income. So that is not in, my lord, there is no records to show that what is right now, what she is doing. So considering my lord, loss of future income is because of the disability has to be calculated. But when there is no loss of income, when she is continuing when she has joined the company or some other work and she is continuing in the job, no question of granting the on the head of future loss of income.
But are you agreeing that the doctor has given the evidence of 15% disability?
Yes, I have no issues on that aspect.
Then how you cannot give compensation to her for loss of disability?
The loss of disability has to be calculated based on the loss of the future income.
Correct, but when there is disability,
As on the
it
date
is
of action, she was
inversely proportional to her earning capacity. If
No,
there
madam.
is disability,
Please.
your ability to work automatically diminishes.
Milord, that is the Milord, main issue. She was studying in 6th semester, Milord, at the time of action. And tribunal, Milord, held that there was no loss of academic year. She has
6th semester of what?
Of a diploma engineering. Milord.
Diploma student.
Milord, she has continued, she has completed her studies. There was no loss of academic year as per the Milord, the discussion held by the MSc.
But her earning capacity comes down.
Earning capacity, Milord, to calculate the earning capacity, whether what she is doing right now, whether she has no job, whether she has joined any company, that is the main issue, Milord. That is the main issue.
And how are you going to answer Kajol's case? How are you
That's
going
why
to answer Master Mallikarjun's case?
Mr.
How you are
Master
going to
Mallikarjun-
answer other Supreme Court judgments of
Master
medical
Mallikarjun-
student, engineering student studying and awarded 10,000 and 20,000?
Milord, Master Mallikarjun case, Milord, is only to the within age of 15 years. So that is not applicable to the case on hand.
No.
Milord.
What I mean to say is when a 15-year-old boy can be awarded compensation by calculating some amount, when a 2-year-old child can be awarded compensation, why not a 6th semester student of diploma?
It is only a type of measurement. It is only
When a first-year MBBS student can be awarded, when a law student can be awarded, when engineering student can be awarded.
That's why my humble submission is future loss of amenities pain and suffering that can be enhanced, compensation may be enhanced, but future loss of earnings to calculate it's difficult. I think I will leave it to last week. I have no issue.
The reason is I have already Keshav Prashant, just for your knowledge, I have already held in several judgments awarding compensation to law students, medical students, engineering students. See, you cannot hold that because they are students, they are not going to earn, or their ability is not going to be diminished because of the disability.
Yes. 100%, Milord. That is the analogy required.
You have to take a holistic approach.
Yes.
The welfare legislation also. We will take 6,000. In fact, it should be more. The chart value is coming in your aid.
Actually, income ಬಗ್ಗೆ they have not narrated anything. Anyway, Milord, I will leave it lots of holistic.
And one more, let me also tell you, I have also taken a view that this income chart is only advisory, it is not mandatory.
True. I agree with that.
So it is the discretion of the court based on a student whose ability to increase the amount of salary. This is only for police. This is only for coolie. He is not a coolie, he is a diploma. Diploma engineers are the ones who are constructing buildings. Of course, they are not doing metro building now, which is fallen down.
Saibri mattu jaasti kodbeku iddan
having regard to the qualification, it has to be assessed. I'm not disputing it. But what should
6,500
I will leave it to last.
6,500 into 12 into 18 into 15. Have you cross-examined doctor with regard to disability?
I don't have any judgment except
Leave it, you go by that. All others retained?
Retained.
Now, what about this contributory negligence?
That is 60% company is to be held liable. That is the TVS and.
So the court has held 40% of compensation as against the TVS. That is you.
No, 60%.
60% Keshav Prasad. You payment ಮಾಡಿದ್ದೀರಾ? You're satisfied?
Yes.
I am satisfied. 60% is against TVS. 40% is against L'Oreal.
So yours is 60%.
Yes.
FIR is filed against whom?
The FIR charge sheet is against me only. Against me only. Against the driver of the lorry in question. But considering the Mahajar, spot sketch and other aspects, tribunal held that rider of the TVS is responsible to the extent of 60% and driver of lorry is extent of.
That will retain because you are not in appeal. Have you filed appeal?
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರ ಅಪೀಲ್ ಹಾಕಕ್ಕಾಗಲ್ಲ ಬಿಕಾಸ್ ಮೆಲಾಟ್ ದೇ ಹ್ಯಾವ್ ಎಕ್ಸಾನರೇಟೆಡ್. As far as Pradeep is concerned, Malad, he is
Exonerate. All right, you want to argue, you can argue.
At the end of this thing, Malad,
Gain recovery, why?
gain recovery will happen.
Huh? No deal. Now, where have you made a attempt to see that he is the one who has contributed? Because of no deal. So pay and recover. Work out. That's all. Heard the learned counsel for the appellant Sripad V. Shastri, learned counsel Keshav Prasant for R1, learned counsel B. Pradeep for R4. Appeal is preferred by the claimant, agreed by sponsors.
Sorry for the interruption, Malad. If your lordship permits, Malad, my matter is reaching in division bench.
Yes, you can exit. Yes, permitted.
Please.
The vehement contention of learned counsel for the claimant. The tribunal has committed an error in not awarding just and reasonable compensation. The tribunal has given a go-by to award compensation under the head loss of income duty due to disability. The counsel further contends that the tribunal has committed an error in dismissing the claim petition as against the insurance company of the TVS. That is insurance company respondent number 4, who is the insurer of respondent number 2.
3. Okay, the TVS respondent number 3 is the owner.
Respondent number 3. On these grounds, he seeks to allow the appeal and consequently award just and reasonable compensation by enhancing the same. It's the vehement contention of learned counsel appearing representing the respondents number 1 and 4, who are the insurance companies of the lorry and the TVS. Another TVS moped, huh? What is that?
Yes, TVS moped.
TVS Vega.
Excel moped.
TVS Vega. TVS Vego. That the judgment and award of the tribunal is in accordance to law, both on the basis of oral and documentary evidence. The same does not call for interference. In view of non-production of any material proof with regard to income, the tribunal has awarded suitable compensation which does not call for interference. Learned counsel representing the respondent number 1, that is the insurer of the lorry, vehemently contends and that the tribunal is right in fastening 60% of the contributory negligence as against the rider of the TVS Vego scooter, and that the 40% liability fastened on the insurer of the lorry has been satisfied. Therefore, he sustains the order passed by the tribunal as there being no error committed by the tribunal and seeks for dismissal of the claim petition. On the contrary, learned counsel representing respondent number 4, the insurer of the TVS Vego scooter, contends that the tribunal has not committed any error with regard to fastening the liability with regard to exonerating the insurance company as the owner of the TVS Vego scooter did not possess a valid and effective driving license as on date of occurrence of accidents, and thereby the liability fastened on the owner is correct, which does not call for interference. Having heard, and on this basis, he seeks dismissal of this appeal. Having heard learned counsel for the appellant as well as the respondents, the point that arises for consideration before this court is whether the claimant has made out a case for enhancement of compensation. What order? Stop. Error. It's not in dispute that the accident occurred on 23/4/2011, wherein the claimant was a pillion ride traveling in TVS Wego vehicle bearing number A41S2523, ridden by one Bhavya. And at that time, a lorry bearing KA 16A2378 came in a rash and negligent manner and dashed against the said vehicle, due to which the claimant sustained grievous injuries and had taken treatment in Unity Lifeline Hospital. And thereafter, she had, due to the sustaining of injuries, she sustained the following injuries: fracture of right humerus, right ulna, left tempora, frontal SDH, and expended huge amount towards her medical treatment. To the contention of learned counsel for the appellant that claimant was a student of 6th semester of diploma in engineering, and due to the injuries, she is unable to lead her normal life by earning good and reasonable income commensurate to her educational qualification and degrees. The injuries sustained by the claimant and disability encountered by her has diminished the earning capacity due to the rash and negligent act of both the vehicles, namely lorry as well as TVS Wego. In view of the same, she has filed the present claim petition seeking enhancement of compensation. The tribunal has awarded various amounts under various heads. The claimant is mainly aggrieved by the non-awarding of compensation under the head loss of income due to disability. Full stop. The claimant was aged 21 years as on date of occurrence of accident, was hale and healthy, and was a student of 6th semester, a bright student of 6th semester, would have gone on to earn handsome salary if her medical and condition was not affected by the accident caused due to the negligent act of the respondent. Claimant has sustained disability to an extent of 15% as stated by the doctor who's examined as PW2 before the tribunal. And the same is not controverted or proved to be not genuine or fabricated. It is also a fact that PW2 is the doctor who has treated the claimant, and he has deposed before the court, and he has withstood the cross-examination without being shaken in the evidence. Same is to be retained as no contra evidence is forthcoming. The accident having occurred in the year 2011.
Oh, 2011.
The notional income would have to be taken as the claimant was a student of 6th semester doing diploma engineering. We of the same, The notional income chart for the accident year 2011 prescribes income at 6,500 per month. Same is taken as income in the present case of the claimant. The loss of earning capacity would be 6,500 into 12 into 18 into 15%. Customer? 2,10,600 is taken as loss of income due to disability. The multiplier is right, is 18 of the age of claimant being 21. Full stop. With regard to other compensation awarded, the medical expenses of 1,10,000, of 50,000. How many days you were inpatient?
4 days, madam, the first time. So two surgeries underwent. The remaining, I am not asking for.
Food nourishment, conveyance, loss of marriage prospect, disfigurement of hand, mental agony due to academic result, future medical expenses, loss of happiness and future amenities due to permanent disability are all not interfered and not disturbed. Same is retained. The only addition to the total compensation awarded by the tribunal is an amount of rupees 2,10,600 under the head loss of income due to disability. Full stop. The other aspect of the matter which is questioned is with regard to fastening of liability as against the respondent number
3.
Respondent number 4, the insurer of respondent number 3. Respondent number 3. Respondent number 3 is the person who was TVS, owner of the TVS. Respondent number 3 has been fastened the liability of 60% by the tribunal, and the insurance company of respondent number 4 has been exonerated by the tribunal. I'm afraid this may not be the correct principle to be followed of the fact that admittedly the insurance policy was in force, and the respondent number 4, being the insurer of respondent number 3, cannot be absolved of the liability merely for the reason that respondent number, the rider of the scooter did not possess a valid and effective driving license. This would squarely come within the theory of pay and recover, and accordingly, respondent number 4 is liable to be fastened with the compensation of 60% as ordered by the tribunal, and would be at liberty to recover the same from respondent number 3. In view of the above discussions, I pass the following order. Appeal is partly allowed. Judgment and award is modified. Claimant is entitled to total compensation of dash as against 3,70,000. The respondent number 3 are jointly liable to pay the compensation of 60% to the claimant and 40% attributed by the tribunal as against respondent number 1 and 2 is retained. In view of policy being in force with regard to respondent number 3, respondent number 4 is liable to make good the compensation of payment of 60% to the claimant and would be at liberty to recover the same from respondent number 3. Stop. The entire compensation shall be, it is stated by learned counsel appearing for respondent number 1 and 2 that he has satisfied the entire amount of his share of 40%. Therefore, the remaining 60% would have to be satisfied by respondent number 4 in favor of the claimant, which shall be paid from the date of petition till realization at 6% interest. What is your interest?
6.
Interest. What is the interest?
Interest.
Hotel, with 6% interest. All right. The balance amount of compensation shall be paid within a period of 6 weeks from the date of receipt of copy of this order.
Number 3.
Yes, why Passover was taken? No, it's up to you. You want to argue, you argue. Argue. Yes.
After we was have entered into an agreement, commissioners have entered into an agreement with SPA number. Phone number 4 and his family members. And then I just see page 36. They have below and David have entered into an agreement with 2007 has entered into an agreement.
Who are you?
Residential property, which is 1 acre 36 lakhs. As per agreement itself dated 19/4/2007, section 36.
So it was a grant land of 1959.
The grant certificate was on 1961. Purchase after entering into an agreement to sell the TBA has been executed by the entire family members. Based on that, have obtained the permission, applied for the permission, applied for the permission, and obtained the permission. Permission was
Permission for what? From the government. Permission is granted.
So the permission was granted in the grandfather's name, original grant. Was required for corrections. That has been sent for corrections. So parallelly, the responding of 5 I filed an PDCL case for cancellation of agreement to sell and
When?
In the year 2015.
Permission was given in 2015. When did the grantee file?
He filed it in the year 2013.
Before the grant, before the permission.
Permission was in the year 2010. I applied for permission. They did not yet the property in favor of for getting the permission to comply the conditions of permissions have opened purchase the
So
property.
when did the grantee petition the AC? All right. When is the order passed?
Was on
22/8/22. Synopsis ali idiyal re. I'm reading the synopsis. 22/8/22. What happened? Restored.
The sale agreement as well as
Declared as null and void. It's pending. Then what is your right here? You filed an appeal.
This I filed a appeal, but no stay has been granted. Now we are making empty reports.
Who are the respondents? Four is the party. Who's in? You're in possession. What are you doing in the land? Cultivating. All right. What is the prayer you are seeking? And dispose of the writ petition, giving liberty to you to go and approach the DC in the appeal and continue this interim order till there. But then we will require respondent number 4. All right, Barkol. Third, learned counsel for the petitioner. Learned High Court government leader accepts notice for respondent 1 to 3. You High Court government leader, huh? Yaವಾಗ AG ಆಗದು. Issue emergent notice to respondent number 4. Learned counsel for the petitioner is permitted to take out notice on the counsel representing respondent number 4 for the respondent number 1, deputy commissioner. All proceedings nadita ilva? Then you take out to the counsel there. There shall be stay of operation of impugned order dated 22/8/2022 passed by the second respondent at annexure A. No grounds made out, Mr. Ravi Shankar. Appeal ಹಾಕಿದಿರಲ್ಲ ನೀವು ಅಲ್ಲಿ. ಏನೋ ಹೇಳಿದಾರೆ.
Also, it gets used well, not was possible. Section 5 and then section 5 appeal and I'm Sovereign Court better than the used to choose that been charged. Intermission should be edited to part of
No, what I will do, I will grant you stay. Then permit you to go and appear before the DC after the appearance of R4 and explore the possibility of the dispute there before the DC. But anyway, I'll have to hear R4 grantee before I pass. I've already passed an order. You take out notice on R4. In birthday. By annexure, the detail annexure ಬರ್ಕೊಂಡು till next date of hearing. Release this matter after service of notice to R4. Which para you wanted to read?
So far as the alternative remedy is concerned. The permission is only that once prior permission is granted, it is out.
The permission can be granted by the government.
Or sale of Sovereign Court, the revision gets taken the view that this is not an absolute bar. What is required for the permission? It is another court division. Further and said that there is no absolute bar under the scheme of the Act. An agreement that a document contemporaneously executed provides for obtaining the prior permission and then execution of the same deed are valid documents in the eye of law and cannot be censored.
But wait, again, that's on. We'll have to go on the facts of the matter. Whether
the ultimate reflects that some of the courts have been Justice Indra also saying the agreement stipulates you have to purchase the property before has been passed. Here the permission is already granted. Permission having been granted, what they did when the permission was granted.
What if the grantee is able to prove that the permission itself was fraudulently taken? No, the scheme of section 4 and 5 primarily is made as a welfare legislation to see that the depressed society or class of people are not taken for a ride on the ground of there being poverty and ignorance of law and knowledge.
Since going against his property, then doesn't seminar say this? Unless property is I will not be given the permission. It is a case where going against property was purchased in the name of the grantee. He took the property, the same thing. He got the khata checks. After getting the same thing in his favor and after the permission is granted, he was before the get me back. This is the answer. Okay.
Yes. We finished the and all other matters we'll take up because there is some difficulty to proceed further.
Serial number 74, my lord. Serial number 74. My lord, interim order will have to be continued, my lord. I am for the petition.
74 interim order, if any, is continued till next date of hearing.
Yes.
Yes, Mr. Sunge. ನಿಮಗೆ wait ಮಾಡ್ತಾ ಮಾಡ್ತಾ ಅವರು ಕಣ್ಣೂರ್ಗೆ ಹೋಗ್ಬಿಡ್ತೀರಾ. He's getting some. Mr. Kiran is here. I think you are appointed amicus with your permission. So I think you can read those papers. We'll take it tomorrow or day after. Day after? Friday. Monday. Just go through it. All right. Yes, Mr. Sunge, Monday. ನೀವು ಇವಾಗಲೇ ಹೇಳ್ಬೇಡಿ ಅವರು let him spend the weekend peacefully and come back on Monday. He can at least go to Kannur and visit Kerala and come back Monday. ಲಕ್ಷ್ಮೀ ನರಸಿಂಹ ನಗ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ನಂದು 62 ಇತ್ತು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವಾಗಲೂ ತಗೊಳ್ಳಿ ಬೇಡ. ಅಣ್ಣ ರೆಡಿ ಇದ್ದೆ, ಅವ್ರು ಬರ್ತಿದಾರೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ.
All other matters you can take a suitable date. Interim order wherever it is there, it will be extended till next week.
Hello, court officer, madam. Madam, ಇದು serial number 44 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಮ್ಯಾಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಪಾಸ್ ಓವರ್ ಆಗಿರೋದು ಯಾವುದು? ಎಷ್ಟೇ
ಆಫ್ಟರ್ 2 ವೀಕ್ಸ್ ಅಂತ ಕೇಳ್ಕೊಂಡು ಹೋದ್ರು ಅವರು.
ಓ